sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private Bond Court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond Court is now in session.
Didn't exist.
Usted me está pidiendo que yo revoque algo que no existe.
He would have been on pretrial release for that case. The pretrial release should be revoked.
Él debería haber estado en libertad provisional por ese caso y se debería revocar la libertad provisional.
Counsel, I'm not seeing that he was arrested on that particular case.
Licenciado, no estoy viendo que él fue arrestado en ese caso en particular.
I see a citation.
Veo una citación.
I see an arraignment scheduled for 7/22.
Veo una vista incoatoria programada para el 22 de julio.
And I see that he failed to appear.
Y veo una falta de comparecencia.
But I don't see that there was ever an ROR or pretrial release or anything of that nature.
Pero no veo nada semejante a una libertad bajo palabra o libertad provisional.
I believe the citation is the arrest in that case, but as there's no prior order of a pretrial release conditions, I'll withdraw the motion.
Yo creo que la citación muestra como un arresto, pero como no hay una orden anterior, voy a retirar mi pedimento.
The court will not be taking any action in 2020 CT 1457.
No voy a tomar ninguna acción en el 20 CT 1457.
Anything further?
Nothing further from the state on this case.
Nada más por parte de la Fiscalía.
Anything further from defense?
¿Defensa? Nada por parte de la defensa, su señoría.
Thank you, Mr. Baird. Have a good
Thank you.
day. Mr. Barrera, would you kindly make an announcement to see if we have anyone else needing your services?
Certainly, Your Honor. Su atención, por favor, si hay alguna otra persona presente que necesite los servicios del intérprete, por favor, alce la mano en este momento.
Well, I don't see anyone on my right, but I can't see the left.
Here in the courtroom, Your Honor.
Thank you, Mr. Barrera. Have a good day.
You as well, Your Honor. Thank you.
Robinson Thomas Cardona-Ruiz.
He is present and approaching, Your Honor.
Thank you. Good morning, sir. State your name
Good morning, Your Honor. Robinson Cardona-Ruiz,
and your date of birth, please.
11/4/1993.
Thank you. Sir, you've been picked up as a result of robbery, petty theft, and a battery. Court has reviewed the charging affidavit. I do find that there is sufficient probable cause. Bond to be set on count 1 in the amount of $5,000. Count 2, the amount of $250. Count 3, the amount of $500. You're not to return to the advanced auto parts. You're not to have any contact with the victim. And you're not to have any association with the co-defendants. Do you understand?
Yes, Your Honor. May I address the court?
I would advise that you not do so because everything that you say can and will be used against you by the state. But if you wish to address the court, you're welcome to.
Understood. I understand everything is being recorded. As to count 1, does the court find probable cause after thoroughly reading the charging affidavit?
Yes, sir, I did. I found probable cause as to all 3 charges.
Thank you, Your Honor.
You're welcome, sir. Thank you. Alan Leonard Smith III.
He is present and approaching, Your Honor.
Yes. Hi, hello. My name is Alan Smith III.
And your date of birth, please.
4/1/70.
Thank you. I'm sorry?
I would like to advise the court that in the process of everything that had happened, I am bipolar, manic depressive with psychosis. So I was under the influence of my medication. And
Mr. Smith, I'm going to advise that you not say anything further because everything you say is being recorded and can and will be used against you by the state of Florida. Do you understand?
yes, I do understand this, ma'am.
Thank you. You've been picked up as a result of robbery, petty theft, and battery. The court has reviewed the arrest affidavit. I do find that there's sufficient probable cause as to all three charges. Bond to be set on count 1 in the amount of $5,000. Count 2, the amount of $250. Count 3, the amount of $500. You're not to return to the advanced auto parts. You're to have no contact with the victim and no association with your co-defendants. Thank you.
Yes, thank you, ma'am.
Kennedius Walden.
He is present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Kennedius Walden, 11/23/1998.
Thank you. Sir, you've been picked up as a result of robbery, petty theft, and battery. The court has reviewed the arrest affidavit. I do find there's sufficient probable cause as to all three charges. Bond to be set on count 1 in the amount of $5,000. Count 2, the amount of $250. Count 3, the amount of $500. You're not to return to the advanced auto parts. You're to have no contact with the victim and no association with the co-defendants. Do you understand? Thank you, sir. Angelique Hazley.
She has refused, Your Honor.
Oh, well, I'm going to go ahead and proceed without her. I will be waiving her appearance.
Yes, Your Honor.
She's been picked up on an out-of-county warrant out of Orange County. Count 1, the bond was set at $2,000. Count 2, the bond was set in the amount of $1,000 for a total bond amount of $3,000. She can either bond out or they will be notified that she's here and ready for pickup.
Thank you, Your Honor.
Thank you. Henry Brown.
He is present and approaching, Your Honor.
Henry Brown, birthday 10/1/65.
Thank you. Mr. Brown, you've been picked up as a result of battery, simple touch, or strike. Court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You do not qualify for pretrial release. Bond to be set in the amount of $1,000. You're not to have any contact with Cynthia Brown. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
Additionally, you're not to return to 3135 Crestwood Circle, Unit F. You can go back one time with the assistance of law enforcement to obtain your personal items. As for 22 CF 536, the court will not be taking any action. Thank you.
Thank you, ma'am.
Tiffany Cox.
She is present and approaching, Your Honor.
Good afternoon.
Cox, birthday March 21st, 1996.
Thank you. Ms. Cox, you've been picked up as a result of possession of controlled substance as well as possession or use of drug paraphernalia. Court has reviewed the charging affidavit. I do find there is sufficient probable cause. You qualify for direct pretrial release, but I will not be granting that. Bond to be set in the amount of $1,000 on count 1, $500 on count 2. You're not to have any alcohol or drugs. Thank you. Carolyn Cruz.
She is present and approaching, Your Honor.
Good afternoon.
Carolyn Cruz, 12/29/90.
Thank you. Ma'am, you've been picked up as a result of driving under the influence with .08 or more, fleeing and eluding law enforcement officer with lights and sirens activated. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You do not qualify for pretrial release. Bond to be set on count 1 in the amount of $500, count 2 the amount of $1,000. You're not to possess or consume any alcohol or drugs. Thank you. Eric Gayer.
He is present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Eric Gare, 3/24/93.
Thank you. Sir, you've been picked up as a result of possession of controlled substance and possession or use of drug paraphernalia. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. State, are you wishing to be heard?
Yes, Your Honor. For the court's information, Mr. Gayer was on probation in 2021 CF 3605. The state is asking that the court find an on-view violation at this time.
All right, can I deal with the first one?
Yes, Your Honor.
Thank you. With regard to possession of controlled substance, bond to be set in the amount of $1,000. Count 2, bond will be set in the amount of $500. You're not to possess or consume any alcohol or drugs. With regard to 21 CF 3605, court will be finding an on-view violation, setting the bond at 0. With regard to 21 CT 6869, court will be revoking and setting at 0. Thank you.
Thank you.
Roland Hayes.
He is present and approaching, Your Honor.
Good afternoon, Your Honor. Roland Hayes II, date of birth 5/31/1962.
Thank you. Mr. Hayes, you've been picked up as a result of aggravated assault with deadly weapon without an intent to kill. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $2,500. You're not to have any contact with Darren Davis. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, Your Honor.
You're not to return to 3720 Ricky Lane in St. Cloud, and you're not to possess any weapons or firearms. Thank you.
Thank you, Your Honor. Thank you for your time.
Drew Hopper.
He is present and approaching, Your Honor.
Drew Hopper, 13097.
Thank you. Mr. Hopper, you've been picked up as a result of battery, touch, or strike. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. You qualify for pretrial release with a bond. That pretrial release with the bond will be in the amount of $1,000. You're not to have any contact with Rosemary McKay. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, Your Honor.
Additionally, you're not to return to 1110 Tapestry Drive. Thank you. Bradley Singer.
Oh, he's in the hospital, Your Honor.
He's in the hospital.
Yes, ma'am.
All right, well, we will reset him when he is available.
Okay.
I have it for the next 2 weeks, so
Okay.
surely he'll be available by then. Antoinette Warren.
She is present and approaching, Your Honor.
Good afternoon. My name is Antoinette Warren, August 29, 1992.
Thank you. Ma'am, you've been picked up as a result of battery, touch, or strike. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,000. You're to have no contact with Terrence Reyes. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand? You're also not to possess or consume any alcohol or drugs, and you're not to possess any weapons or firearms. Thank you. David Kearse.
He is present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
David Kersey, 789.
Thank you. Mr. Kersey, you've been, you're seeing me today on charges, 3 different charges of violation of domestic violence injunction. The court has reviewed the charging affidavit. I do find sufficient probable cause as to each charge. Bond will be set at the amount of $1,000 on each charge, so that's a total of $3,000. You are not to have any contact with Iris Evelyn Matei. Nope. Let me finish, please. No contact means no in-person contact, no telephone contact, no third-party contact, no social media contact, no contact whatsoever. Do you understand?
Yes, ma'am.
You also are to abide by the terms of the injunction that have been entered. Do you understand?
Yes, ma'am.
Thank you, sir. John Bilheimer?
He is present and approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Hi, John Michael Bilheimer, August 24th, 1957.
Thank you. Sir, you've been picked up as a result of trespass after warning. The court has reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond to be set in the amount of $500. You do not qualify for pretrial release. You are not to return to 2655 North John Young Parkway. That is the 7-Eleven. As for 21MM 9269, the court will not be taking any action. Thank you. Ms. Smith, do you have anyone else over there that we've missed?
No, Your Honor. Oh, actually, we do have one that, my apologies, that they wanted to bring in last, Denise Viola.
Oh, I don't have paperwork on
Bonded.
her. Apparently she bonded. Okay.
News to me, Your Honor. Thank you.
Thank you, counsel. I'm sure I'll see you at some point later this week.
I am sure. Have a great day.
Thank you, you too.
Yeah.
Nogira Rivera, case number 2022 CF 6446AO, and case number 2022 CT 3083AO, and case number 2022 CT 3084AO. And he is in the process of being fitted with the headphones. He now is wearing the headphones. You can let me know when you are connected.
Your Honor, the interpreter can confirm there's connection.
All right, Mr. Rivera, the court finds probable cause in your cases for possession of cocaine. Bond remains set at $2,500. And your second case, count 1, DUI. Bond remains set at $500, and refusal bond remains set at $500. I am appointing the public defender to represent you in your case, sir. Thank you. Mr. Interpreter, I believe that's the only case for you. I thought there were a couple, but that's the only one.
Thank you, Your Honor. Have a great day.
You too. Andrew Deshaun Edward. Are you Mr. Edward? Sir, are you Mr. Edward? What's your name, sir?
Hello, your name?
Hello?
Dominic Edwards.
Okay, Mr. Edwards. The court finds probable cause in your case.
Your Honor, the state did convey an offer for Mr. Edwards of
Go
an
ahead.
adjudication of guilt,
Mhm.
credit time served, and no return to the Circle K gas station at 6250 West Colonial.
Judge, they didn't tell me I was trespass.
Hold on one moment, Mr. Edwards. What's that noise?
I don't.
Oh, okay. Because of the fact that we're having the intermittent noise, all parties, whenever the noise is going, just stop talking because I can't hear you. And you're going to wind up having to repeat yourself. I'll also stop talking when I hear the noise because you can't hear me, and I'll wind up having to repeat myself.
Can't hear over noise. Okay, I know that. So come on.
Okay. Ms. George.
Your Honor, just ask that you set a bond in this case.
The court finds probable cause. Bond remains at $150. The court will further order no return to the location where this incident occurred as a condition of bond. Thank you. Roger Loman. As to Roger Loman, Ms. Public Defender, I've reviewed his paperwork and do find probable cause. Would you like for me to waive his appearance?
Yes, Your Honor.
All right, his appearance is waived, and the court does find probable cause for resisting officer bond stays at $500. The court will take no action on the out on bond case. James Moore.
My name is Joseph.
Joseph?
Oh, I have more, James.
Okay, Okay, we have, this jacket says James Moore. Is there an AKA?
Another one.
Okay. I don't have a file for Joseph Moore. Okay. That says James. So is it in here?
It's a felony?
Traffic.
Well, yeah. No, they suspended him
Do I have one of these for him?
last Tuesday.
This should be, this is his.
That says James.
This one's Joseph. The case was.
Joseph, yes, Joseph. All right, Mr. Moore, Joseph Moore?
Yes.
The court finds probable cause in your case for driving on a license that was suspended or revoked.
Your Honor, state did convey an offer to Mr. Moore of an adjudication of guilt, credit time served. However, he may qualify for PTD downtown.
Additionally, the court would need to see his driving record. It's always a concern of whether someone will become a habitual traffic offender. What order are these in?
So there's all four of them, Your Honor. I put them in order as they should come across, but he was a move up, so he'll be in.
Okay, this is Joseph Moore. All right, here it is.
I don't believe he'd be habitualized, Your Honor.
All right, just looking here at the driving record. These are the old ones. Court's concerned that someone probably needs to advise him on the habitual traffic offender statute. So with regard to that offer, you need to consult with the lawyer.
Can I tell him about it?
Of course,
Okay,
that's right.
I didn't know if you wanted me to.
Yes, I'd like you to consult with them. Okay. Is Mr. Moore currently on probation?
I think I am. Yes,
All right, we're not gonna resolve this case today. It's not gonna happen.
They won't.
Court finds probable cause for the charge of driving on a suspended license with knowledge, and bond will remain set at $500.
$500, Your Honor?
Yes, ma'am. The defendant is currently on probation in Seminole County, so we don't want to put him in danger of violating his probation. Probably already violated, though. Brandon Keith Buckles. Mr. Buckles, the court finds probable cause in your case as follows. Count 1, robbery, sudden snatching, bond stays at $1,000. Count 2, battery on a person 65 years of age or older, bond is set at $500. Count 3, petty theft, bond stays at $100, and criminal mischief, bond stays at $100. The court is ordering as a condition of bond that you have no contact with the victim, that you not return to the location where this incident occurred, with the exception of No, that you just not return to the location where this incident occurred. Thank you, sir.
Your Honor, he has an additional case as well.
ROR, I have a pet I need to take care of.
Hold on one moment. Let me just
Yes, Your Honor.
be sure I'm hearing what you're saying. Ms. Fleming?
Yes, he also has another case. You read off the charges from the 6457 case.
Yes, ma'am.
He also has the 6456.
Do we have the 6456 case?
Wait, that's not my law office, right? Why does it say law office?
Oh, yes, the 6456. Let's
All right,
just-
ma'am, I have a private attorney I need to get in contact with. I'm unable to do that in here. Additionally, I have a pet I need to take care of.
I cannot understand anything you're saying.
I have a private attorney. Well, how are you going to understand?
Put it back on.
Yes, sir.
Just talk a little slower
I have a private attorney.
and into the microphone. You have a private attorney.
Yes, ma'am. I have a private attorney. I'm unable to get in contact with an attorney here. Additionally, I have responsibilities outside of here, including a job and pets to take care of. I would like to respectfully ask for ROR because I cannot afford these bond amounts.
All right, thank you, sir. I have heard what you've had to say. Let me just look at this second case.
It's the same narrative, Your Honor, it's just two different victims. that-
Yes, that's what I was confirming. I want to be 100% sure of that. All right, sir. As to the second case, the court also does find probable cause for the charge of robbery by sudden snatching, and bond will stay at $1,000 in that case. As to the charge of battery, court finds probable cause and sets a bond of $500. Petty theft, bond will stay set at $100, and criminal mischief, bond will stay set at $100. As a condition of this, a bond in this case as well, the court is ordering no contact with that victim and no return to the location where this incident occurred.
How much money do I need to have to get out of jail in total?
Let me just finish, sir. In terms of your motion, where you have asked the court to consider an ROR that's denied, you must consult with your attorney. Your attorney is authorized to file a bond motion in the division where these cases are set, and can at that time make your request formally to the judge that's assigned to the case concerning your request for release on recognizance. All right, thank you, sir.
I'm sorry, one more thing, Your Honor. I motion to have this case moved out of district. I have two other related cases, one
That's
in Osceola
denied,
County
sir.
and one in Orange County that must be moved to
Sir,
the
that's
Supreme Court.
denied.
David P. John. Reason he was investigated by the World Trade Universe. David P. Johnson, associated with the World Trade Universe.
Before I go to the Marquisha Lena Dean case?
Yes.
Okay. All right. Okay. Case number 22 CT 2950AO. Shaleed Louis Moto. Shaleed Moto. All right, we'll reset this case due to medical. This is an in-jail arraignment. The PD was previously appointed in this case. Ms. George, would you want me to reset it, or what do you want to do?
No, Your Honor, I will waive and enter a plea of not guilty.
All right, plea of not guilty entered, case is set. Was it a bill?
No, it's a
Set for pretrial conference.
Division 84 pretrial conference, July 7th at 8:45, courtroom 4B.
Okay, case 2021 CT 6310AO. In this case, the public defender was also appointed. The defendant is Saul Isaiah Valentine. Medical, Ms. Public Defender.
I will waive and enter a plea of not guilty, Your Honor.
All right, Ms. Public
It's a
Defender.
VOP.
Denial. Sorry.
Yeah, enter a denial, which is accepted, and the case will be scheduled for VOP status.
Division 85 VOP status, June 17th at 9 o'clock, courtroom 4A.
Kurt Boston, case number 2022 MM 3169AO, set for an in-jail arraignment on a charge of battery.
I will enter a plea of not guilty, Your Honor.
Plea of not guilty entered. This case will be scheduled for a pretrial conference. He's been in jail 25 days, Miss Public Defender. Pretrial conference in, is it DV or regular battery? Well, you know what division it is.
Division 81, pretrial conference, June 30th at 9 o'clock, courtroom 6B.
Thank you, Madam Clerk. Danny Garcia, 2022 MM 2983AO. Mr. Garcia is here for an in-jail arraignment. Public defender was previously appointed. He's been in jail 34 days.
Yes, Your Honor, state did convey an offer to Mr. Garcia of an adjudication of guilt, credit time served, no return to Walmart at 2271 North Cimarron Boulevard, and restitution to Walmart in the amount of $63.85.
Does your client wish to accept this offer?
Yes, Your Honor.
Are you stipulating to a factual basis, or is the state able to provide me with a factual basis in this case? All right.
Mr. Garcia would like to accept and enter a plea of no contest.
May I see the plea form? And the 34 days is his time served?
Yes, Judge.
Okay.
How long have you kept
I don't know what the hold is for.
Mr. Garcia, sir, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
Did you read this plea form before you signed it, sir?
Yes, Your Honor.
Do you understand that by entering your plea of no contest, you are giving up all the rights on this plea form?
Yes, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you're not a United States citizen?
Yes, ma'am.
And are you under the influence of any alcohol, drugs, or medicine?
No.
All right, the court finds that there's a sufficient factual basis based on stipulation of counsel. You're alert, you're intelligent. I'll adjudicate you guilty. Order 34 days in jail. You have credit for 34 days time served. Further, sir, I am ordering you not to return to the Walmart where this incident occurred, and that you pay restitution of $63.85 to Walmart, as well as mandatory court costs.
How do I pay that?
I'll order you to pay it within 180 days of your release from incarceration to the clerk of courts.
I received disability, so it won't be like on time, it will be.
You can pay $20 a month, but just pay it all within 180 days if you can. If you are unable to pay the full amount, you may request an extension of the payment from the clerk of courts.
That's fine, thank you.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. It's paid within 180 days.
Okay.
Thank you.
Okay, bye-bye, have a nice day, thank you.
Your Honor,
You have a nice day.
May I approach with a restitution order?
You may. Tatum Gerhart, 22 MM 2730AO, is scheduled for an in-jail arraignment. The public defender was previously appointed in this case as well.
We will enter a plea of not guilty, Your Honor.
Plea of not guilty entered. Cases, there you go, Madam Clerk.
Division 81, pretrial conference, June 30th at 9 o'clock, courtroom 6B.
Michael Hendricks, 2022 MM 2881AO. Mr. Hendricks? All right, you're here for an in-jail arraignment on a trespass charge. Yes, the public defender was previously appointed, Ms. George.
We will enter a plea of not guilty.
All right, plea of not guilty.
Division 81, pretrial conference, June 30th at 9 o'clock, courtroom 6B.
Thank you. Christopher Johnson, case number 2022 MM 3143AO.
He's medical.
All right, Mr. George, you are appointed to represent Mr. Johnson.
Yes, I will waive and enter a plea of not guilty.
All right, plea of not guilty entered.
Division 84, pretrial conference, July 7th at 8:45, courtroom 4B.
Timothy Dwayne Lyman, 2022 MO 555AO.
Your Honor, the offer from the state is an adjudication of guilt, credit time served. There is a $10 filing fee and court costs. Mr. Lyman would like to accept an interplea of no contest.
So there's a count to 1 and a count to 2.
Yes, Your Honor, it'd be an adjudication credit time served on both.
All right, and concurrent?
Ms. Judge.
Concurrent, okay. And is the state able to provide a factual basis, or is the defendant stipulating?
Defense will stipulate.
All right. May I have a plea form?
Yes, Your Honor.
All right there, Mr. Lyman, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs and medicine this afternoon?
No, ma'am.
You understand a conviction on this case will subject you to being deported if you're not a United States citizen?
Yes, ma'am.
Based on stipulation of counsel, I find there is a sufficient factual basis. I find you to be alert and intelligent, and I will adjudicate you guilty. Order you to serve 41 days in jail on count 1 and count 2 to run concurrent with credit for 41 days time served. Further, I'm ordering you to pay a $10 filing fee and all mandatory court costs, which must be paid within 180 days of your release from incarceration, and I am releasing you as to this charge. You must make your payments with the clerk of courts. If you're unable to make the full payment as I have ordered, then you must request an extension of time from the clerk of courts. Any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit.
Thank you, ma'am.
Christopher Antonio Taylor, 2022 MM 3207AO. He's appointed to your office, Ms. George.
I will waive an interplea of not guilty.
All right, plea of not guilty entered.
Division 80, pretrial conference, July 25th at 9 o'clock, courtroom 9C.
All right, that concludes the Angela arraignments. Markeisha Lene Dean.
Excuse me.
Oh, was that a sneeze?
It was a hiccup.
Well, then bless you. Bless all of us. Bless everybody. Bless the whole world. I think I covered everybody. Ms. Dean, ma'am, the court finds probable cause in your case for the charge of petty theft. Bond stays at $250. No action on the out on bond case.
Your Honor, state would ask for a no return.
The court is ordering you not to return to the location where this incident occurred as a condition of your bond, ma'am. Thank you, ma'am. Yes, ma'am. On this case, you can. Yes, ma'am. Chastity Gonzalez Barros. I did find probable cause on this case, Ms. George. I am appointing your office to represent the individual.
I will waive the appearance, Your Honor.
All right, probable cause is found, and the case bond stays set in this case at $1,000. The court orders no return as a condition of bond. Clifford Good. The court finds probable cause in your case for petty theft with prior theft conviction, and bond stays at $500. You're ordered to not return to the location where this incident occurred as a condition of bond, and the court will take no action on the out on bond. Thank you. John McAlevey.
Yes.
Mr. McAlevey, the court finds probable cause in your case for trespass on property after a warning.
Your Honor, state did convey an offer to
Yes, ma'am.
Mr. McAlevey of a withhold of adjudication, credit time served, no return. He otherwise would most likely qualify for PTR or PTD. However, I do believe he's from out of the country.
All right, in Mr. Loman's case, sorry, he's not Mr. Loman, he does not qualify for PTR. The court would have set a bond of $1,000 in this case if that's, if he does not wish to take the state's offer. The state, is offering a withhold based on that he has no prior state?
Yes, Your Honor.
Okay,
And Your Honor, he would like to accept the state's offer and enter a plea of no contest.
all right. How much time served does he have?
2 days.
Just 2 days? All right, sir. What's your name?
Kyle McAlevey.
All right, Mr. McAlevey, is this your signature here at the bottom of this plea form?
Yes.
Did you read this plea form in its entirety before you signed it?
No.
You didn't read it? Can you read? All right, just stay there. The deputy will bring it to you. Just let me know when you finish reading it. I am appointing the public defender on all cases unless I say otherwise. And I have appointed them on all cases this afternoon.
And this one as well, Your Honor?
Yes, ma'am?
I thought you said you didn't qualify, sorry.
Mm-hmm.
Yeah, thank you very much.
All right, Mr. McAlevey, have you had a chance now to read the plea form? Do you understand that by entering a plea of no contest, you're giving up the rights on the plea form? Are you under the influence of any alcohol or drugs or medication today? Do you understand that a conviction on this case will subject you to being deported if you're not a United States citizen?
I am British, so I'm not.
Well, you're not a United States citizen, so do you understand that a conviction on this case will subject you to deportation if you are not a U.S. citizen?
I'll be deported straight away.
You're subject to deportation.
Okay.
I cannot tell you if you would be deported ever or if you would be deported straight away. So I have no idea. Do you want to consult more with an attorney about it first, or? Would you like to proceed, or would you like to withdraw your plea?
Proceed.
All right. Do you understand the question I asked, that a conviction on the case will subject you to deportation if you're not a U.S. citizen?
Yes.
There is a sufficient factual basis. You're alert, you're intelligent. I will withhold adjudication of guilt, order 2 days in jail with credit for the 2 days you already served. You must also pay mandatory court costs in this case, and you must not return to the location where this incident occurred, nor have any contact with the manager or the representative of the establishment.
And Your Honor, may I have a one-time return, just to grab his belongings?
Okay.
I'll give you a one-time return within 48 hours to retrieve all your personal belongings. Additionally, sir, the court costs must be paid within 180 days. Thank you. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. James Irvin Moore.
Behavior.
I did find probable cause in that case, and I will be appointing a public defender.
Can we reset for tomorrow? There was an offer to resolve, Your Honor.
Sure. Case will be reset for tomorrow. Douglas Noel.
Yes, ma'am.
Mull, sorry. Sir, the court finds probable cause in your case for disorderly intoxication, and bond will stay set at $250 in that case.
Your Honor, there was an offer to resolve of an adjudication of guilt, credit time served. Mr. Moe would like to accept and enter a plea of no contest.
How much time served does he have?
2 days.
All right, that's acceptable to the court.
Gotta wait and go.
Has he read that plea form?
Yes.
Okay,
Yes, ma'am.
okay. Is this your signature here at the bottom of this plea form, Ms. Manoel?
Yes.
Did you read this plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine this afternoon?
No, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you are not a U.S. citizen?
Yes, ma'am.
All right, sir, there is a sufficient factual basis in your case. You are alert, you are intelligent. At this time, I will adjudicate you guilty, order 2 days in jail with credit for 2 days' time served, order you to pay mandatory court costs within 180 days of your release, and I am releasing you as to discharge. Do you have any questions?
No, ma'am. Thank you.
You have a right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. No action on the out on bond case.
Yes, ma'am.
Wendy Ehrlich Williams. Wendy Williams. Ms. Williams, ma'am, the court finds probable cause in your case for petty theft, and you do qualify for a PTR program. I'll order PTR or a $250 bond. And as a condition of both PTR or bond, you must not return to the location where this incident occurred. Okay, and I am appointing the public defender, so thank you, ma'am. 250. No, yeah. Just for clarification, PTR or bond?
Yes, Your Honor.
Okay, just gotta get it right. Gabrielle Carmona. The court does, actually, you were picked up for failure to appear. Bond will stay set at $250 in your case for failure to appear.
Your Honor, state's actually going to announce a null pros.
Okay, state's announcing a null pros in this case. So that will take care of that.
I'm filing it now for the clerk.
All right, thank you. You'll receive your paperwork shortly, sir. Ricky, the court will order his release as to this case. Ricky Irizarry.
Bonded.
Previously bonded per the, somebody said it. I don't know who said it. Per the jail people. Previously bonded. Luanne Martin.
I'm Luanne Martin.
Okay, Mr. Martin. The court, you were picked up for failure to appear. Bond will stay set at $500 on count 1 and $100 on count 2. And I am appointing a public defender on your case. Thank you, sir. Armani Casanova.
Yes, ma'am.
The court finds probable cause in your case for disorderly conduct. Bond stays set at $250, and the court is further ordering that you not return to the location where this incident occurred as a condition of your bond.
Your Honor, there is an offer of a withhold credit time served and court costs to resolve the case.
How much time served does he have?
2 days. Well, 1 day.
All right. Yes, ma'am. Has he read a plea form?
We went over the plea form together, and he would like to accept and enter a plea of no contest, Your Honor.
All right. Mr. Casanova, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it, sir?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine this afternoon?
No, ma'am.
Do you understand that a conviction on this case will subject you to deportation if you're not a United States citizen?
Yes, ma'am.
All right, there is a sufficient factual basis. You're alert, you're intelligent. I will withhold adjudication of guilt, order 2 days in jail with credit for the 2 days you've served. I will further order mandatory court costs. All monies must be paid within 180 days of your release. I am ordering your release as to discharge, sir. Court will take no action on the out on bond case. Thank you, sir.
Thank you.
Sebastian Fernandez. Mr. Fernandez, the court finds probable cause for disorderly conduct, and bond will stay set at $250 in that case.
Your Honor, there is an offer of an adjudication of guilt, credit time served, and court costs.
How much time served does he have?
2 days.
All right, that's acceptable.
And Your Honor, for as far as the court costs, I would ask for a year to pay the court costs.
That's granted.
Thank you.
Thank you a lot. I'm trying to change my life, Judge.
I didn't hear what you said.
I'm trying to change my life, and
Okay, well, I'm gonna give you a year, and I'll give you plenty of time to pay these court costs, a little bit at a time. Mr. Fernandez, is this your signature here at the bottom of this plea form?
yes, ma'am.
Did you read this plea form, sir, in its entirety?
Yes, I did, ma'am.
Do you understand that by entering a plea of no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine today?
No, I am not.
Do you understand that a conviction on this case will subject you to deportation if you're not a United States citizen?
I understand.
There is a sufficient factual basis. You are alert, you're intelligent. I'll adjudicate you guilty, order 2 days in jail with credit for the 2 days you've served, and order you to pay mandatory court costs. You have 364 days to pay all of the court costs. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions?
No questions, ma'am.
All right, thank you. You may exit for your paperwork. Daniel Moncada,
Bonded?
bonded per the jail staff. Yeshua Rodriguez,
Bonded?
bonded per the jail staff. Richard Thomas Scarborough. All right, Mr. Scarborough, the court does find probable cause in your case for disorderly conduct, and bond will stay set at $250 in that case.
And Your Honor, the offer from the state is an adjudication of guilt, credit time served, and court costs. Mr. Scarborough would like to accept and enter a plea of no contest.
Does he have 2 days credit?
Yes, Your Honor.
All right, I'll accept that. Has he read that plea form?
Yes, ma'am.
All right, just bring me the plea form and then I'll go forward with the plea. Mr. Scarborough, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this document in its entirety before you signed it?
Yes, ma'am.
Sir, are you under the influence of any alcohol, drugs, or medicine this afternoon?
No, ma'am.
Do you understand that by entering the plea of no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
And do you understand that a conviction on this case will subject you to deportation if you are not a United States citizen?
Yes, ma'am.
All right, there is a sufficient factual basis. You are alert, you are intelligent. I'll adjudicate you guilty. Order 2 days in jail, credit for the 2 days you have already served. Further, sir, I will order mandatory court costs in this case, which must be paid within 180 days of your release, and I am ordering your release as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit.
Yes, ma'am. Thank you.
Noel Alvarez. Noel Alvarez.
Can we skip him? He's actually deaf. On our paper, they got his hearing impaired.
Okay.
The headphones are not even, he said he can't hear anything.
So does he read sign language? No? No, okay. Ms. Public Defender, I am appointing your office to represent Noel Alvarez.
Yes.
And I would be finding probable cause. Is there any motion that you would like to make?
I would just ask for pretrial release in this case, Your Honor, given that he qualifies.
Yes, ma'am. But are you waiving the fact of?
Yes, Your Honor, I will
Okay.
waive.
All right. So at this time, the court does agree that the defendant qualifies for PTR based on the information I've received. I will order the defendant released on PTR or bond of, and I do find probable cause for each count, bond of $1,000 on count 1, $500 on count 2, $150 on count 3, and $100 on count 4. And as a condition of PTR or a condition of bond, the defendant must consume or possess no alcohol and submit himself to random alcohol testing. Random alcohol testing.
And Your Honor, given the, I guess the issue with communicating, I wrote pretrial release and asked him the question.
Yes,
here.
ma'am.
You would like just straight pretrial release in this case?
No bonds?
No bonds, Your Honor.
All right, the court will order pretrial release. And all of the words that I spoke related to bond are canceled. The court is also ordering that the defendant not drive as a condition of his pretrial release status. Okay. No, I was ordering that in case he decided to do the bond. So I modified the PTR order to delete the random alcohol monitoring. I still am ordering he consume or possess no alcoholic beverages, but I'm not ordering him to be monitored for that as long as he isn't driving. Shaquanda Rashal Dave, thank you, sir.
You, Your Honor.
All right, thank you. Shaquanda Rashal Davis. Ms. Davis, you were picked up for failing to appear. Bond will stay set at $500 in that case. Thank you, ma'am. Next, we have Jason Bartlett. Mr. Bartlett, the court does find probable cause in your case as follows. Count 1, grand theft of a motor vehicle. Bond stays at $2,500. Count 2, possession of fentanyl. Bond is stays set at $2,000. And count 3, possession of paraphernalia. Bond is set at $100. Thank you, sir.
Your Honor, state would ask for no contact with the victim.
Yes, ma'am, that's granted. The court will further order no contact with the victim in this case as a condition of bond.
Was that man released?
Carlin Gillens.
They got a PTA?
I'm sorry, sir.
Not a PTA?
I don't understand what he's saying.
PTA, return? Do I get-
PTR, I believe.
PTR?
Oh, so, no, sir, you don't qualify.
Why not?
Well, let me see his
I didn't
PTR.
even get to talk about anything. I'm out of state. The thing got, that, I didn't steal the car.
Stop talking about the facts.
I think it's the lack of community ties, Your Honor, and
So,
recent failure to appear.
From the state.
no, sir, you do not qualify. The defendant does not have any community ties to verify or confirm. The defendant stated he's been in Orlando for, it looks like a month, and sometimes stays in a hotel, sometimes not. He is not sure when he's going back to Connecticut. Sir, you don't have the community ties necessary to qualify for PTR. There may be other reasons as well, but that's the reason that I was given as of today. Do you understand? Thank you, sir.
And Your Honor, since he does not qualify, would you consider lowering the bond amount on count 1 to 1,000?
I see it, the,
2,000, so that he's able to bond out through a bail bonding?
What says the state?
Your Honor, I say there's no objection to 1,500 on 1 and 1,000 on 2.
The court will partially grant that motion, and the court will reduce the bond to $1,500 as to count 1, and the bond is reduced to $1,000 as to count 2, stays at $100 as to count 3. Thank you. Oh, there are a lot of reasons why he doesn't qualify. All right. Carlin Gillens?
Yes, ma'am.
All right. The court finds probable cause in your case for count 1 burglary of a dwelling. Bond stays set at $5,000 in that case. And trespassing on a structure or conveyance, bond stays at $100. Conditions of bond are that you have no contact with the victim and not return to the location where this incident occurred. Thank you, sir. Brian Godley. Are you Brian Godley? All right. The court finds probable cause for grand theft, 3rd degree of motor vehicle. In your case, bond will stay set at $2,500. You're ordered to have no contact with the victim and not return to the location where this incident occurred. Thank you. Holt Robert James Kopke. Bonded per the jail staff. Rodney Patrick. Sir, the court finds probable cause as follows. Count 1, possession of cocaine, bond stays at $1,000. Count 2, possession of cannabis, bond stays at $1,000. Count 3, possession of cocaine with the intention to sell or deliver, bond stays at $1,500.
Yeah.
Your Honor, are you setting at 1,500?
I'm sorry, $15,000. I'm making so many mistakes this afternoon. It is $15,000, sir.
Your Honor, I would ask,
Yes, ma'am.
I was originally going to argue the PC issue. However, I would ask, given the facts of this case, that you consider reducing the $15,000 bond amount. In this particular case, he was not the driver, and although he did admit in the arrest affidavit to having marijuana in the glove box, there is no indication that that bag belonged to my client. All of the drugs that were found were located inside of the bag, and being next to the bag alone is not sufficient for constructive possession. So I would just ask that, given all of the facts in the case, that you consider reducing the bond amount on count 3 to $5,000, Your Honor.
Does the state have any objection?
Yes, Your Honor. I mean, the book bag was in the floorboard by his feet, and he stated that his fingerprints would be all over the bag. So state would object.
Court will deny the motion. Lamont Rivers, Tyrone Lamont Rivers. Where's the Rodney Patrick? The court finds probable cause as follows. Count 1, possession of cannabis with intent to sell or deliver with a weapon. Bond will stay set at $15,000. Count 2, possession of firearm by a convicted felon. Bond will stay set at $1,150. Count 3, possession of a firearm by a convicted felon. Bond will stay set at $150. Count 4, possession of a firearm by a convicted felon. Bond stays at $150. Count 5, grand theft of a firearm. Bond stays at $150. And count 6, possession of cannabis. Bond stays at $150. The court is further ordering a revocation of the bond as to the auto bond case, both count 1 and count 2. Bond is set at no bond. Billy Wright. Billy Wright. As to the charge of aggravated assault with a weapon, the court finds probable cause. Bond stays set at $2,500. You are ordered to have no contact with the victim and not return to the location where this incident occurred. Possess no weapons and no firearms as a condition of bond, and surrender any weapons or firearms to law enforcement within 24 hours of your release. As to the other case, the out on bond case, the bond is revoked and bond is, new bond is set at $5,000. Thank you, sir. You gotta recycle over here.
Yes.
Are there any other cases?
Nothing from the
Court
state.
stands in recess.
Okay. For the purposes of record, today is May 31st. This is the 8:30 calendar for preliminary hearings. My name is Brad Gardner. I'm going to be presiding over these hearings. I'm going to call a calendar. When you hear your case call, please make the appropriate announcement. Position number 1 is Rashad Battle.
Your Honor, for Mr. Battle, defense is ready.
Okay, and that's gonna be here?
Yes, Your Honor.
Okay,
Your Honor, the state is ready pending arrival of the officer.
okay. And that's Officer Loudon, it appears.
Yes, Your Honor.
Okay. Yes, sir. Position number 3 is State versus Jesse Bray. It's listed as Lister and Hope, Mr.
I think you're muted, Mr. Lane.
Yes, Your Honor. Mark Lane on behalf of Mr. Bray. At this point, no one from our firm has been able to meet with Mr. Bray, so I'd request to be able to meet with him briefly before the hearing.
Okay.
What is it about Battle?
Hearing.
Okay. Position number 4 is State versus Lucky Brock.
Your Honor, Mr. Brock appears to be unrepresented at this time.
Yes, that's what's showing. So it's criminal trespass. So we'll bring Mr. Brock up and see what he wants to do.
And Your Honor, the state's ready pending officer, arrival of the officer, who is the same officer for position 1.
Yes, allowing. Position number 5, State versus Marquise Busby.
Your Honor, Mr. Busby is ready to proceed with the preliminary hearing.
Okay.
Your Honor, the state's ready pending arrival of the officer.
Okay. Position 6 is State versus Jackie Fleming.
Fleming, Your Honor, I was unable to meet with her at the jail. We attempted several times. I would need a conference with her before I can make further announcement, Your Honor.
Okay. And let me ask you this, Mr. Little, just for my own edification. I'm learning that it seems like you all may try to meet with the person like via Zoom or something, and the person is just not accepting the call.
Sometimes that happens. Sometimes it is a logistical problem at the jail. If they don't have a guard available. I know last week they were doing some repairs on some cell doors, so that prevented certain blocks from being able to have visits. Sometimes it can be a mental health issue, and we don't find that out until we get a chance to speak to them, because if they don't have the ability to figure out how to log into the kiosk, they can't get to the video visits, and we won't really discover that until we speak to them in court and find out that that's the issue.
So would you just please spread the word, because from my standpoint, I want to cut down user error, and I want to find the problems and fix the problems. And I think I don't know what you encounter when you're trying to do what you're trying to do, because I honestly, my 22-year career, have never done video visits. So I have no idea how that process works. And if it's something that we need to get involved in, I'm happy to be the person that try to help to make that happen. But you gotta tell me. Okay.
That's something we really do need to look into, because we can't, the calendars are too large.
Definitely.
Yeah.
It's hard to know because it's never just one problem. It'll be like many different problems that could come up in any individual visit.
And that's the I guess my point is, if it's something that you see that's reoccurring, that means that that's a problem that maybe we can fix. But the one-offs of, stuff it just happened that day, can't necessarily make policy off of a one-off thing. But just please know, because we want to move this stuff and get your clients to where they need to go.
I agree, Your Honor.
Okay.
We can also go to the jail and see them, Judge, too.
Yeah. And that's, it's in this new world, I don't make presumptions because I'm not experiencing it. But just if there's something that we can do to help, please let us know.
Thank you, Your Honor.
Okay. Position number 8, State of Georgia versus Leroy Grayer.
Mr. Grayer is ready for his hearing, Your Honor.
Okay.
And Your Honor, the state's ready pending arrival of the officer.
And looks like it's Brianka Farley. Okay. Position number 9, State of Georgia versus Sean Hampton.
Yes, Your Honor, Mark Lane, on behalf of Mr. Hampton, we're ready for hearing.
Okay.
Your Honor, the state's ready pending arrival of the officer.
Okay. Position 11, State of Georgia versus Justin Harris.
Mr. Harris is ready for his hearing, and he has 2 positions, Your Honor. He should also be the next case.
He is, but he's also on the 3rd case with Mr. Harris. Mr. Little, he appeared before me maybe 2 weeks ago, and he had the first charge, and then there's a second charge that we thought he was just brought back in error. So I said he doesn't have to come back because I didn't know that it was a new charge. But then there was a new charge. But now I see on the calendar that he has 3 charges of the same offense. 2 are CWs and 1 is a WA. Did you know about the 3rd charge?
No, Your Honor, I knew about the 2 of them.
So I have 2022 CW 52294, sexual battery. I have 2022 WA 08116, sexual battery. And I have 2022 CW 52316 as sexual battery. So I believe I was on the 2nd, the 316 CW, that he appeared before me, and looks like he's gotten another charge, but they're all the same offense. So it's Officer Mitchell for the CWs, and then there's Officer Wynn for the WA. That position 12 on my calendar. So it appears, and I don't know for certain, but my understanding is that it may have been basically the same kind of conduct, and they have his phone, and that the officers may have been reaching out to people that they identified as being on the phone. And I'll tell you, Ms. Jefferson, just from looking at the warrants that I saw, I think there's a question. There's possibly going to be a question about the charges, but we'll let that sit until we get to that case.
Yes,
so
Your Honor.
that's going to be a hearing, Mr. Little.
Yes, Your Honor. Are we prepared to do all 3 of them, or is there one of those warrants that's not on the calendar?
The last one is on the last page of the calendar.
Oh, okay.
But it also involves Officer Mitchell. So if we have Officer Mitchell for the 2022 CW 52294, then we can do the 2022 CW 52316.
Your Honor, the state is at somewhat of a disadvantage here because the calendar that I have has two of the three warrants, and I've got Officer Nguyen, I could be mispronouncing that, and Officer Mitchell. But I don't have the other. You said that there were two warrants with Officer Mitchell, I believe I heard.
Yes, the Officer Mitchell saw two warrants. And the just the way that it played out, I believe on the day Mr. Harris was arrested, and he appeared on a Tuesday with, I think, Judge Banda. And then I came back on Wednesday and I saw his name, and I saw that he had been on the calendar the day before, and the same charge. And so I said, well, hey, looks like he was placed on the calendar in error. But it appears to be, at least from the 52316, I think that's the one that I dealt with at first appearance. And I just placed the same bond as Judge Bando had done on the prior incident. But it's the same, it appears to be the same conduct of using a phone, and I and we'll get into it when we are at the hearing, but I don't know if it meets the elements of sexual battery. But that's something that's what the hearing is for us to get into it. Position 13, State of Georgia versus Delmonte Jones.
Your Honor, it seems that Jones is out to bond, if I can get confirmation from the jail.
Okay. Do you have Mr. Jones there at the jail? Can you hear? Okay.
Yes, sir. We checking right now.
No, he's out to bond.
He's out to bond? Okay. So that case will be transferred over.
Yes, sir. He's out on bonds.
Okay, thank you. Position 15, State of Georgia versus Dwayne Keith.
Keith is ready, Your Honor.
That's going to be a hearing?
Yes, Your Honor.
Okay.
And Judge, the state is ready pending arrival of the officer.
I don't see an officer listed. Do you know the name of the officer?
M. Kale.
Okay.
I could be massacring that last name.
That's fine. I do it all the time. Miss Jefferson. State of Georgia versus Antoinette LeMay.
Your Honor, it looks like Mr. LeMay was appointed to the Public Defender's Office before he was put on this calendar. We could submit an appointment order and then we would be ready to represent him, Your Honor.
Okay. Do you know if this is a situation? No. Looks like he shouldn't have been placed on this calendar. So I'm looking at the WA numbers and they're in sequence 6465. So that would tell me that they occurred on the same day. So he should be on the felony calendar and not the misdemeanor calendar.
And that would sort of make sense, Your Honor, since you did get appointed to the Public Defender's Office.
Yes. Okay. Well, I'm going to Miss Mary, and you make sure you keep me straight on this. But it looks like Mr. LeMay needs to be placed over onto the felony calendar.
I'll double check before I move him.
Okay. We'll come back to that, Mr. Lowe. Position 19, State of Georgia versus Sheena Lindsay Smith.
Yes, Your Honor, Mark Lane on behalf of Miss Lindsay Smith, and we're ready for hearing.
Okay.
You're on the state's
I have she's out to bond. She's out to bond.
Miss Lindsay Smith?
Yes.
Okay.
Okay.
Thank you for the update.
Mr. Lane, are you just willy-nilly just announcing a hearing?
Your Honor, I just met with her and she was in jail just the other day, so that was.
Yeah. Let's confirm over at the jail. Let's just make sure that Miss Lindsay Smith is out the bond.
Your Honor, she's not on our calendar.
Okay. So it looks like she's out the bond. She pulled a fast one on you, Mr. Lane.
It looks like it.
Position 22, State of Georgia versus Samuel McCullough.
Your Honor, we have a waiver prepared for that one that we can submit to the court.
Okay. I have my pen. I'm ready to sign. As they say, have pen will travel. Position number 23, State of Georgia versus Kenyon Myrick.
Apologize, Your Honor. Myrick. It looks like the video visitation system from Myrick is, let me read it, currently does not have access to it, so I would have to request a conference, Your Honor.
Okay.
Did we skip Morgan? No.
I don't have a Morgan.
Corey Morgan, Your Honor, is position 48.
Okay. Let's see. Corey Morgan. Is that your client, Mr. Suh?
Yes, Your Honor. Okay. Oh, just out of alphabetical order. Gotcha. I'll wait for the proper time to make an announcement to Morgan.
Okay. Position number, let's see. Position 25, State of Georgia versus Reginald Oliver.
Oliver is ready for a hearing, Your Honor.
Okay.
And Judge says say it'll be ready pending arrival of the officer.
Well, Judge, I have him out to bond, so you might want to check.
Or Oliver?
Reginald Oliver?
It says out the bond on my calendar.
Looks like he made it. Your Honor, I visited with him last week, so he may have made bond over the weekend, I guess.
Maybe family's Russian.
Do you still have Reginald Oliver at the jail?
Yes, sir, he's here this morning.
Okay.
Okay.
So it looks like there will be a hearing.
Interesting. I wonder if, because the jail law, if I look him up in the jail's inmate search, it does not show him.
What's his full
There's
name?
a Reginald.
What's his full name?
I have Reginald Oliver on my calendar, charged with speeding, fleeing from an officer, improper lane change, and another charge that's not listed.
Can you give me his middle name?
I don't have a middle name showing.
Do y'all have I have an LA number.
It's Reginald Corvin Oliver Jr.
Yes, sir, he's down here.
If he's there, we're ready, Your Honor.
Okay. Okay. State of Georgia versus Tamunjan Perkins.
Your Honor, I was unable to meet with Mr. Perkins. I would request a conference for him, Your Honor.
Okay.
And Judge, the state is ready, the officer, Officer Lamb. I see Officer Lamb.
Okay, I see Officer Lamb too.
Your Honor,
I'm sorry.
this is the jail, Mr. Perkins.
Uh-huh.
Him and another inmate had got into a fight, but we still have Mr. Perkins down here for court.
Okay. Position 31, State of Georgia versus Darius Reese.
Mark Lane on behalf of Mr. Reese, and we're ready for hearing.
Judge, the state is ready. Officer Farley. I see Officer Farley. And Officer Farley, I believe, is also here for another case.
I didn't get that.
Oh,
Could you try
sorry.
again?
Theory is participating in the conversation, sorry. Officer Farley is also here for another case, Greer as well.
Okay. All right. And what I'm going to try to do is roll over into these hearings for cases that announce that they have hearings and we have the officers here so that we can move people off the calendar and try to make best use of our time. Position 32, State of Georgia versus Jadarius Sanders.
Good morning, Your Honor. Karen Pass for Mr. Sanders.
Good morning, Ms. Pass. How are you?
I'm good. How are you?
I'm doing well.
Good.
Is that going to be a hearing or?
I mean, I can be ready for one. He's been in there for a while, Judge, and we couldn't find anything on him till Miss Moultrie finally got all the paperwork in the correct place. I've also ordered the police report and haven't gotten that either. But I mean, it is a misdemeanor, a battery or simple battery, so I could have a hearing. But also, I believe Miss Moultrie said you would entertain a bond hearing after this.
I would. Did you notify the state?
I did. They knew about it. I think it was Miss Blau, and she was going to reach out to me and see if we could work out a consent, but I never heard from her, so I'm not sure where we stand with that.
Okay. Miss Jefferson, do you know about this case?
Your Honor, I'll just need a moment when we have a break to check on that.
Okay, and I'll let you and Miss Pass speak. Because there's just, when it came to my attention, there's some sort of, I guess, intricate moments or issues that it's probably best that you and Miss Pass speak about this before you bring it to my attention. So what I'm going to do, Miss Pass, what I'm going to do is I'm going to try to get these officers out after I call the calendar. Then I'm going to place you in a breakout room with Miss Jefferson so you can speak about Mr. Sanders. Then I'm going to place the lawyers from Lister and Hope in a breakout room at the jail so that they can speak to their clients that they need to speak to. But that's going to be after we get some of these hearings out of the way. Okay.
Yes, sure. Thank you.
You're welcome. Position 33, State of Georgia versus William Sesser.
Your Honor, it's my understanding that Sesser is out to bond, if I can get confirmation from the jail.
That's what's listed on my calendar. Do we have the jail? Are you guys there?
William Sesser.
Yes, sir. Yes, sir.
Over there said non-applicable.
Okay, these look like these right here, 'cause
Do you have Mr. Sesser there?
We double checking now, sir.
No, I don't think.
Okay.
He's not over here.
No, sir, we don't have him.
Okay. All right. So I'm gonna confirm that he's out the bond. I feel like sometimes like a Southern Baptist preacher. It's like, is there anyone within the hearing of my voice? Can you say amen? Okay, State of Georgia versus Marissa Van.
It looks like Van is also out to bond, if I can get confirmation from the jail.
Okay. Do we have Marissa? Do you have Marissa Toriana Van at the jail?
She was released. Your Honor, she was released on 5/29.
Okay, thank you. Position 36.
I'm sorry, Your Honor.
Yeah.
For that case, Ms. Van, that is Officer Clevenger, I believe. Where is Officer Clevenger? Officer Clevenger, were you here on that case for Marissa Van?
Yes, ma'am.
And that's your only case, correct?
That's correct.
So, Your Honor, if the officer can be excused, being that Ms. Van has bonded out.
Yes, Officer Clevenger, you can be released. Enjoy the rest of your day.
Thank you, Your Honor.
Okay. Position 36, Monterio Watkins, Mr. Lane.
Yes, Your Honor, that's my case and we're ready for hearing.
Okay.
Your Honor, the state is ready and I thought I saw the officer. Officer Flowers.
Yes, ma'am, I'm still here.
Oh, sorry.
Yes.
Officer Flowers, yes.
That's gonna be the first case. Position 38, State of Georgia versus Willie Williams.
Yes, Your Honor, Mark Lane on behalf of Mr. Williams. This is one where I would need to meet with my client prior to the hearing. I haven't had a chance to try to visit with him and it was unsuccessful.
Okay, position 40, State of Georgia versus Dominic Alexander.
Your Honor, we are ready to proceed with the preliminary hearing.
And Judge, the state is ready, Your Honor, pending arrival of the officer.
Okay. Position 41, State of Georgia versus Khadija Delavo.
Defense is ready, Your Honor.
Okay, and that was you, Mr. Little.
Yes, Your Honor.
And Your Honor, the state is ready pending arrival of the officer. That's Officer Bowling.
Okay.
Okay.
Position, I'm sorry.
Oh, I'm so sorry. I'll unmute myself.
Position 45, State of Georgia versus Deonta Lewis.
Mark Lane on behalf of Mr. Lewis, we're ready for hearing.
Okay.
And Your Honor, the state is also ready. Officer Plummer.
Appears to be here.
Plummer is here. Yes, Your Honor.
Yes. Okay, position 46, State of Georgia versus Tracy Mathis.
Your Honor, Miss Mathis was continued from last week. She's a case where there's some mental health issues involved, and we continued it in the hopes that we could find a bed available for her at Georgia Regional and maybe do like a consent bond agreement, have her sent to Georgia Regional. And speaking with her nurses, they don't have a space for her yet. So I would request to continue this to next week's calendar if we could, to give us more time to see if we can find a place for Miss Mathis to go.
What's the state's position?
Your Honor, we're ready for a hearing pending arrival of the officer. However, I can speak to Mr. Little as we get closer to that case on the calendar.
And Has there been like any discussions ongoing about what it appears Mr. Little is trying to accomplish on behalf of Ms. Mathis?
We spoke about it last week, Your Honor. It's really just if there was a bed available. I mean, the state could possibly consent to just doing a bond agreement. But I mean, if there's not a bed available, it's hard to ask for that.
I understand, and I guess the purpose of my question is to ask if that is within the realm of possibility with the state. If you know, Ms. Jefferson, and I'm not trying to tie your hands, but this is something that if Mr. Little is working on it, as the comic would say, I'm going to be here all night. I'm going to be here all week doing this stuff. And if it's within the realm of possibility, depending on whether Mr. Little can make it happen, then I'd rather do it sooner than later. So if it's not, just let me know right now, and then I can make a decision about what I'm going to do or where I'm going to go.
Well, Your Honor, the state's position is that we cannot agree to a consent bond without some mechanism for Ms. Mathis to be able to be under some type of supervised mental health care.
Okay. And that's fine, and that's reasonable. I just need to understand the state's position so I can try to entertain Mr. Little's motion in the best way possible. Because the thing is, Mr. Little, there's no guarantee that if I grant this continuance today to next week, that bed space is gonna miraculously open up. So it sort of begs the question of what's the best thing to do for Miss Mathis. The case can move to the next stage and maybe something can get worked out. That's final disposition of the case.
What we could do, Your Honor, is we could do like a judicial bind over and I guess just move her on to state court. That way we could still look for bed space and we can always do a bond in state court if we needed to.
I would much rather do that than to just have the case just floating around. But that's a decision that you have to make. So I'll hold tight.
I think that's actually a good idea, Your Honor. I think I'm going to prepare an order for a judicial bind over, requesting that her case be moved to state court because of her mental health issues. But there wouldn't really be a benefit to having a hearing for her because my worry is she wouldn't necessarily know what it is that we're doing.
Right. And there, while we're speaking on that, I've been in active conversations with people for over 12 months now, trying to get mental health services down to state court level and possibly even magistrate court level, because I see it when I'm doing first appearance and the people I interact with. And it's something that's needed for this community. Position 48, State of Georgia versus Corey Morgan. That's your case, Mr. Suh.
Yes, Your Honor, we are ready to proceed. The prelim.
Yeah, there are cases that will be ready pending arrival of the officer.
Okay. Position 49, State of Georgia versus Sanchez Simmons. And that person appears to be unrepresented.
Your Honor, I think that we were supposed to have been appointed on that case last week. But if the order hasn't gone in, we can submit another order. I think it was continued off of last week's calendar. And we should have been appointed on it, Your Honor.
Was there, see, it was Judge Bridgewater.
That's right.
Did she sign an order? Or did you get an order back?
I don't think we got an order back, Your Honor. So that's why I'm like, we could submit another order if we needed to make sure that we get appointed.
Yeah, send it over. And just so you know, as we flip and go from calendar to calendar, stuff like this is not something if it somehow didn't meet Judge Bridgewater for her to sign and send it over, I wouldn't necessarily know about it unless you tell me. So we're going to act under the notion that an order was not signed. And that's unless, Miss Mary, you can tell me that there is an order in the system.
My computer died, so I'm using my phone for Zoom right now, so I can't do that at the moment.
Okay. Okay, well, send that to me, Mr. Little, and I'll appoint you. And are you otherwise capable of handling the hearing today for Mr. Simmons?
Your Honor, actually, I was going to be handling that one for our firm, and due to us recently being, or they tried to appoint us, but we're still in the process of doing that. I would need a chance to meet with her prior to having the hearing because we haven't had a chance to do that. I attempted a scheduled visit on Friday, and it didn't. She wasn't brought up.
Okay. I'll let you, want to get to the point of meeting with the client. I'll let you meet with the client and then give me your report after you've had an opportunity to meet with the client. Position 52, State of Georgia versus Billy Coleman. That it says forgery in the first degree, which is a felony. It shouldn't be on this calendar.
I wasn't necessarily expecting a Coleman to be on this calendar, Your Honor.
Your Honor, I don't have that on my calendar either.
Okay. All right. So this may be something, Miss Mary, that we'll deal with tomorrow. I don't know. Looks like the officer is Dominic Bishop. And the last person on my calendar is Justin Harris, and this is the case that I was telling you about before. The third, apparently, sexual battery charge, Mr. Little.
I think that one I don't necessarily have a police report for. But I mean, other than that, I'd be ready.
Okay. I think with Mr. Harris, the allegations are, if I remember them correctly, it's basically like allegation is that he's using his phone and taking pictures of women. It may have been at like Walmart, and I don't know. Like the one that I saw, it was Walmart. But the concern that I have in it, and this is Ms. Jefferson, something that we'll get to when we're dealing with the hearing. But if I recall it correctly, the concern that I have is like he's taking pictures, but it doesn't appear to be any contact. as it relates to sexual battery. So that's just going to be something that I'm going to be asking questions about at the hearing. So like I said, Ms. Jefferson, I'll tell you what I'm thinking. I'm an open book, and I know I'm wrong a lot of times. So I understand that. So that completes the call of the calendar. Is there any case that I did not call that you expected to be called?
No, Your Honor.
Okay. Let's begin with Mr. Let's see, with Officer Flowers and what's the case? Okay, Officer Flowers, you got to tell me your case because I think
It's Watkins, Judge.
Watkins, thank you. Let's bring up Mr. Watkins. Okay, Mr. Watkins.
Sir.
I just have to caution you that anything you say during this proceeding is not privileged or private. So I don't know, most often persons do not speak, but if there's anything that you want to say and you have not discussed that with Mr. Lane first, I would encourage you not to speak without having the privilege of speaking to your lawyer. So for the purpose of the record, we're calling position 36 on my calendar, State of Georgia versus Montero Watkins. Mr. Watkins is charged in warrant number 2022 WA08166 with committing the offense of obstructing an officer. Mr. Watkins is also charged in warrant number 2022 WA08167 with committing the offense of giving a false name, address, or date of birth. Mr. Watkins is present in court. He's been represented by Mr. Lane. The state is being represented by Ms. Jefferson. Ms. Jefferson, you may swear in your client and proceed with your case.
Officer Flowers, can you raise your right hand, sir? Thank you. Do you swear or affirm the testimony you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
Okay, and if you could state your name and where you're employed.
It's Chris Flowers. I'm a patrol officer with the City of Morrow Police Department.
And in that capacity as a patrol officer, were you working on May 15th, 2022?
Yes, ma'am, I was.
And were you dispatched to the Best Western at 6437 Jonesboro Road? And is that in Clayton County that you were dispatched?
Yes, ma'am, it is.
And can you tell us what happened after you were dispatched that caused you to take out these charges of obstruction and giving false name against Mr. Watkins?
Yes, ma'am. This is the Best Western Hotel. I arrived there and met with an employee who stated that a male was in the breakfast area, that he had been eating their breakfast and he was not a resident of the hotel, and that they wanted him removed from the hotel and they wanted him given a criminal trespass notice. The employee pointed to, who was later identified as Mr. Watkins. He voluntarily stepped out of the breakfast room into the lobby of the hotel and began speaking with myself and Officer Kirby. I explained to him why we were there. I asked him for his information. that being his name and date of birth. And he told me that he was Jonathan Watkins and that his birthday was July 27th of 1982. I went to check that information on GCIC. While I was doing that, Officer Kirby and Mr. Watkins engaged in a conversation that Mr. Watkins was telling him that he was on parole and that they were talking about the different prisons that he had been at. The 911 center told me that information, the Jonathan Watkins of 7/27/82, was not on file, meaning they couldn't find it in the database. So I asked Mr. Watkins again for his information. At this time, he gave me a different birthday. I don't have that written down in my notes, but he gave me a different birthday. And then when I went to confirm that information, this time I went to my in-car computer to check it. And when I checked the different date of birth that he gave me, it returned showing that was an alias for his real name, which is Montario Bernard Watkins, with a different date of birth. It came back showing that he was wanted for parole violation through the Georgia Pardons and Paroles Board. I informed Officer Kirby and we went to detain Mr. Watkins pending the outcome of the warrant, plus the fact that he had given us two dates of birth. When Officer Kirby went to place handcuffs on Mr. Watkins, he pulled away from Officer Kirby and fled on foot approximately a half mile down the street, where we were finally able to take him into custody.
Did you or did Officer Kirby give Mr. Watkins any verbal commands?
Yes, ma'am. As he was fleeing, he was told several times to stop. He was also warned that if he didn't, he would be tased. And he was partially tased a couple of times, but it did not make full connection.
And in those verbal commands, he failed to comply. Is that accurate?
Yes, ma'am.
Thank you. I have nothing further.
Mr. Lane?
Good morning, officer.
Morning.
With your encounter with Mr. Watkins, did you inquire of him as to his mental health?
No, sir.
Okay. And do you know that with certainty, did he understand your commands?
I believe he did. We had a probably 4 to 6 minute conversation prior to him fleeing on foot, with him explaining to us why he was at the hotel. He gave us a very clear explanation of why he was using this hotel's facilities other than the hotel he was checked into, because he couldn't afford the room where the free breakfast was. He had a very clear conversation with us about the facilities that he had been in and that he was on parole. So I believe he completely understood what was going on.
Did he tell you why he fled?
He said because he didn't want to go back to jail.
Okay. Did he also tell you that he was afraid that he was going to be beat?
I don't recall him saying that as a reason, but when we did go to take him into custody at the end of the foot pursuit, he was saying that he was afraid he was going to be beat.
Okay. And how many taser darts were fired into him?
I'm only aware of one that actually hit him, one dart. That's the only one that we located on him. There were 3 different cartridges that were fired at him, but I believe only one of the 6 darts actually hit him.
I have no further questions, Your Honor.
Any follow-up, Ms. Jefferson?
No, Your Honor, the state rests.
Okay, Mr. Lane, do you have any witnesses that you intend to put forward?
No, Your Honor.
Okay, may Officer Flowers be excused?
Whoa, that's a dog.
Yes, unfortunately, that's my dog.
Your Honor, the state will submit on the evidence.
Okay, any argument, Mr. Lane?
No, Your Honor, we'll submit.
Okay, I'm going to find that the evidence is sufficient. First, Officer Flowers, you can be excused. Thank you.
Thank
I'm
you,
gonna
Your Honor.
find that the evidence is gonna be sufficient to bind this case over to the state court of Clayton County. Can we do, let's see, we got, keep you here, Mr. Lane. We got Officer Plummer, I see here, and it's Deonta Lewis is also one of your cases, Mr. Lane.
Yes, Your Honor.
And you announced the hearing. Can we bring up Deonta Lewis or Donta Lewis? Give me 1 second while I bring it up, Mr.
You don't pat him down, so he can go back.
He could go back. No, he don't even ask for it.
No, I'm saying, no, you got to pat him down.
Yeah.
I'm trying to find the last guy. Hey, this Deputy Jackson, name for Holden. This house is even one, right? Yeah, y'all got that Terrence Grisby down there? I don't, it says on my paperwork that he's an intake. I called intake and they said that he's in housing one. Grisby, Grisby.
Deputy, can you guys mute your phone? We can hear you.
Okay, I'm back. I had to get my Snapple to try to keep me from being able to speak. So, Mr. Lewis. Mr. Lewis, sir, this is your preliminary hearing. I just want to caution you that anything you say here is not private or privileged, so please don't say anything you wouldn't want the whole world to know. And definitely don't say anything without speaking to your lawyer first. For the record, this is position 45 on my calendar, State of Georgia versus Deonta Lewis. Mr. Lewis is charged in warrant number 2022 WA 06710 with committing the offense of battery. Mr. Lewis is here represented by Mr. Lane. The state is represented by Ms. Jefferson. Ms. Jefferson, you swear in your witness and present your case.
Officer Plummer, can you unmute yourself? And there you are.
Hello.
Hello. Officer Plummer, can you raise your right hand? Do you swear or affirm the testimony that you're about to give in these proceedings is the whole truth and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand now. And if you could tell us your name and where you're employed.
My name is Officer Milton Plummer. I am currently employed at the Riverdale Police Department.
And were you so employed at the Riverdale Police Department on April 18th, 2022?
That is correct.
And on that day, did you happen to be, or were you dispatched, Officer Plummer, to 6231 Highway 85 Home Suites? And were you dispatched there?
Yes, I was.
And what city is that, was that Home Suites located in?
It is located in Riverdale, Georgia.
So why you on Zoom, you don't make arrests?
Somebody's talking. I'm not quite
That's
sure.
looks like Officer Wynn. I just muted him.
Oh, okay. And that location of the homes, of the homestay suites that is in Clayton County, correct?
Yes, that is correct.
Okay. After being dispatched there on that day, what was the basis or what were the facts that you determined to justify the warrant or the charges that you took out against Mr. Lewis?
On that day, I was dispatched on a dispute at Homestay Suite. Once I arrived, I made contact with, I believe it's a Mr. King, and who had visible bleeding on his lips. He informed me that he was involved in a verbal altercation with a gentleman from another room, and once that verbal altercation began, it turned physical, where that gentleman punched him in the face several times. Mr. King brought me to the room. I knocked, I made contact with Mr. Deontay. He denied having any altercation with that gentleman, but that gentleman continuously insisted that he did have a verbal altercation. Then Mr. Deontay informed me that that gentleman got hurt because he fell. However, the bruises on Mr. King's lips did not coincide with somebody falling. So hence I took Mr. Deontay into custody.
And so he was charged with one warrant or one count of battery, is that correct?
That is correct.
And you saw the visible injury to his face?
Yes, I did.
I have nothing further.
Mr. Lane?
Good morning, officer.
Good morning, sir.
You would have to admit, though, it is possible that he suffered the injury to his lip from falling down, correct?
With the injuries, those did not coincide with somebody who fell.
Well, you can pretty much get injured anywhere when you fall down, wouldn't you say?
You can, but not those injuries that I saw.
And you can say that with a certainty, 100%?
I mean, it can never be 100%, but from my judgment, those were not injuries from someone falling.
When you were speaking with the alleged victim here, did he appear to be intoxicated?
No, he didn't.
How many hours passed after your initial interview of the alleged victim and then your meeting with my client?
You advise how many hours?
Yes, I was curious how many hours had passed by when you arrived on the scene and met with the alleged victim, and then by the time you finally met with my client?
When I arrived on the scene, I spoke to the victim, and he immediately took me to the room where the suspect was. It probably was about 5 minutes.
Okay. And
hold on 1 second. Because I just need to get this right. The question, Officer Plummer, was how much time. Your response, what I heard from your response is it was 5 minutes from you arrived to you spoke to the person, but not necessarily how much time since you received the call till you arrived on the scene. So could you answer?
Oh, I misunderstood. I misunderstood. I received the call, I'm going to say within a 10-minute window of arriving to Homestay.
Okay. Go ahead, Mr. Lane. I'm sorry.
Oh, thank you, Judge. And when you were out there on the scene, how long would you say your investigation took when you were out there?
I'm not quite sure what the relevance is to how long the investigation took. I'm not quite sure where the relevance is to, it doesn't seem relevant.
I'm gonna overrule that. I could understand where Mr. Lane may be trying to go with the temporal like element or time element. So that's what I'm listening to now. And
okay. Well, from my recollection, it's probably approximately 15 to 20 minutes.
Okay. And the injuries to the mouth or the lips of the alleged victim, did you take any pictures?
At the time I had my body camera rolling, but I did not take pictures of the injuries.
Okay. Do you still have that body camera footage?
It should be in records at the Riverdale Police Department.
Okay, and you would produce that to us?
Yes, I could.
All right. Did you ever get my client, Deontay Lewis's version of what happened?
Yes, I did.
Okay, did you put that? Oh, go ahead.
In the beginning, Mr. Lewis denied even having a verbal altercation. It took a while for him to admit a verbal. Then he stated that, oh, he fell.
Okay. And when he said he fell, meaning that the alleged victim just fell down without Mr. Lewis doing anything to him, correct?
Yes, that's correct.
I have no further questions, Your Honor.
Ms. Jefferson, any follow-up?
No, Your Honor, the state rests.
Okay. Mr. Lane, are you intending on presenting any witnesses?
No, Your Honor.
Okay, may Mr. Plummer be excused?
You're in the state will submit.
Okay. Officer Plummer, you can stay or you could be excused. It's your choice. Any argument, Mr. Lane?
No, Your Honor, we'll submit.
Okay. I'm going to find that there's sufficient evidence to bind this case over to state court of Clayton County for trial.
Thank you, Your Honor.
You're welcome. I'm gonna keep you here, Mr. Lane, in the hot seat. I'm gonna call position 9, State of Georgia versus Sean Hampton. That's Officer Ford, who I saw here. How you doing today, Officer Ford? Okay. Can we bring up Sean Bernard Hampton at the jail?
He coming, Your Honor.
Thank you. Mr. Lane, since I have you here, I'm looking through the calendar and seeing the cases that you announced as being hearings. And if I see the officer present, that's why I'm trying to call those cases up. So when I'm done with you and I'm done with the other cases for Mr. Sarah and Mr. Little, then I can allow you guys to go have conversations with your clients and Ms. Pass to have a conversation with Ms. Jefferson. And we'll take a break at that point. But the officers who are already here, I want to try to get them out of the way as much as possible. Okay. Mr. Hampton, sir, this is going to be your preliminary hearing. I got to caution you that anything you may say here is not privileged or private, so please don't say anything you wouldn't want the whole world to hear, and please don't say anything that you haven't had an opportunity to speak to your lawyer about first, okay? For the record, this is position number 9 on my calendar, State of Georgia versus Sean Bernard Hampton. Mr. Hampton is charged in warrant number 2022 WA08214 with committing the offense of simple battery. He's also charged in warrant number 2022 WA08215 with committing the offense of criminal trespass. Mr. Hampton is here present in court. He's been represented by Mr. Lane. The state has been represented by Ms. Jefferson. Ms. Jefferson, you can swear in your witness and present your case.
Officer Ford, can you raise your right hand, please? Do you swear or affirm the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can lower your hand. And if you could state your name and where you're employed.
My name is Officer Kenyon Ford. I'm currently employed with Clayton County Police Department.
And were you so employed with the Clayton County Police Department on May 16, 2022?
Yes.
Or May 17th, rather, 2022?
Yes.
And on that day, did you respond to 10761 Terra Village Way?
Yes.
Okay. And what city is that address in?
That is in Jonesboro.
And is that in Clayton County, sir?
Yes.
And can you tell us the basis for your being dispatched or responding to that location and the basis for the warrants that you, or the charges that you issued, battery and criminal trespass against Mr. Hampton?
Yes. Myself and the other officer, we responded to the call. It was a domestic violence call. The female victim called about her boyfriend, ex-husband, being there. After he had already left, he came back. He was attacking her, and he also damaged the house. We made contact with the victim down the street from our residence as we approached the resident. As we were getting there, she was down the street, like standing on the corner with a neighbor. We spoke with her, asked what was going on. He was still at the residence. She was saying he was just chasing me outside. We spoke with several neighbors who actually was able to corroborate that they did see him chasing her outside. We also made contact with another neighbor who had a Ring door camera, who actually allowed us to view some footage, which revealed him actually attacking her in front of that house.
And officer, the relationship, you spoke to the alleged victim, correct?
Correct.
Okay. And, or Miss Love, you spoke to her and you determined that she and Mr. Hampton had been in a boyfriend-girlfriend relationship?
Correct.
And were they living together at 10761 Terra Village Way?
Yes.
Okay. And what was it that you determined that he damaged?
The back door of the residence. It was kicked in.
Okay. I have nothing further.
Mr. Lane?
Hi, yes, good morning, officer.
How you doing?
Pretty good. Did you notice, or were you able to find out who actually owns the residence?
Who actually owns the residence?
Yes.
That's the property owner. The property owner, no, but they both are currently living at the residence, and he was moving out of the place.
Okay. And it seems like the dispute all started when Miss Love decided to change the code on the front door. Is that correct?
That's correct.
Okay. Do you know if she had permission to do that?
Permission?
Yes, from Mr. Hampton, who was also residing there, and for all I know, may even own the residence.
No, sir. But Mr. Hampton and Ms. Love had already stated he was already gone from the residence. He had came back.
And this footage, do you still have that in your possession?
I do.
Okay. Would you be willing to turn it over to the defense?
I will.
And so we are still unclear who owns the property, correct? Owns the residence?
As a property owner, that's correct. I'm not sure if they were renting or owning.
Okay. All right. I have no further questions, Your Honor.
Ms. Jefferson?
You're on the state rest, but I will have argument.
Okay. May Officer Ford be excused?
Yes, Your Honor.
Okay, Officer Ford, you can choose to stay or leave at your leisure, but you can leave if that's what you want.
Actually, Officer Ford, I think you're here for another case as well.
Oh, okay. I'm sorry. And Ms. Jefferson, when we're done with this, I'm gonna need you to tell me the other case so we can just
Yes,
get
sir.
him out of the way. So, are you gonna open and close, Ms. Jefferson, or are you just gonna waive opening? What's your prerogative?
Your Honor, actually, I'm not going to open close. I'm just going to make a very brief closing argument as it relates to the warrant regarding the criminal trespass damage to property.
Okay, Mr. Lane?
Yes, Your Honor, that's the same. I would submit on the simple battery charge, but the criminal trespass is the one that I would take issue with.
Okay. So I'll hear from you, Mr. Lane, and then I'll hear from Ms. Jefferson.
Just briefly, Your Honor, yeah, on the criminal trespass damage, the alleged damage to the back door, for all we know, my client owns that door. It's unclear. We don't have any proof who owns the residence, who owns, in a sense, who owns the door. And so just based on that, I would argue that there's not probable cause to charge him with that criminal trespass.
Okay, Ms. Jefferson?
Your Honor, my argument was going to be that the state will dismiss that warrant as there isn't evidence to support the probable cause of that warrant.
Okay. So I'll accept that. Ms. Jefferson, that means you're gonna have to send something to me about the dismissal for my signature. So, Mr. Hampton, this charge is going to be dismissed. The criminal trespass, the simple battery is going to be bound over to the state court of Clayton County. And if you would remind me, Ms. Jefferson and Mr. Lane, there's a discussion that I would like to have about the criminal trespass charge, because believe it or not, that's something that myself and Judge Bando have been debating for weeks about criminal trespass and the length that it goes. But it'll be an interesting conversation, I promise. And it'll be offline, but I'd love to hear from the both of you. And even you, Mr. Little, about this criminal trespass. So that we can hopefully all get in line with an understanding of what criminal trespass means. So what's the next case, Ms. Jefferson, for Officer Ford?
Officer Ford, I believe you're also here for a Kenyon Myrick. Is that correct, officer?
Yes, I'm here for the Keenan Myrick case.
Okay.
And Your Honor, this is one of the cases where Mr. Myrick did not have access to the video visitation system. So I do have to request a conference first.
Okay. Well, I'm sorry, Officer Ford. I'm going to have to allow Mr. Suh the opportunity to speak with his client before we proceed with that case. But I'm going to try to move this along as quickly as possible. Let's see. Now, Miss Jefferson, do you have, I see the officers here. Are there cases that you have that you want to call? As Mr. Lane, I think that may end with the cases that you've announced that you wanted to have a hearing on. I don't see your name in my notes for another hearing, but I know you need to speak to maybe one or two clients.
Yes, Your Honor, and there was two more. It was Mr. Reese that I'd announced ready on.
Reese.
And I believe
And that was Officer Farley, who I think I saw.
Yes, Your Honor, Officer Farley, I see Officer Farley here. And Officer Farley is also here for Grayer.
Yes. So, Mr. Lane, we're gonna call for the jail is Darius Cornelius Reese. We're gonna bring up Officer Farley. And on Grayer, I did not write who. I have it listed as a hearing, but I think that was you, Mr. Little.
My case, Your Honor.
Okay. So we'll call that case next, Mr. Little. After Mr. Reese.
Good
morning, Judge.
Good morning. Mr. Reese, this is your preliminary hearing. I have to caution you that anything you say here is not privileged or private, so please don't speak without the knowledge of knowing that whatever you say is being recorded and the whole world can hear it. If you need to speak to your lawyer, I'll give you time to speak to your lawyer if a question comes up, but don't blurt anything out, okay?
Yes, sir.
For the record, this is position 31, State of Georgia versus Darius Cornelius Reese. Mr. Reese is charged in warrant number 2022 CW 51976 with committing the offense of criminal trespass, damage to property. Mr. Reese is here represented by Mr. Lane, and the state is represented by Ms. Jefferson. Ms. Jefferson, you swear in your witness and proceed with your case.
Officer Farley, can you raise your right hand, please? Do you swear or affirm the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
And if you could state your name and where you're employed.
Officer Farley with the Clayton County Police Department.
And were you so employed on April 30th, 2022?
Yes, ma'am.
And on that day, did you respond to 1400 Flat Shoals Road in response to a domestic dispute?
Yes, ma'am.
And where is Flat Shoals Road located?
It's going to be located in what they call now is Atlanta, Georgia. It used to be College Park, Georgia, in Clayton County.
And it is in Clayton County, is that correct, officer?
Yes, ma'am.
And in responding to that location, what did you identify, investigate, determine? What facts did you arrive at to issue a criminal trespass warrant or charge against Mr. Reese?
Once I got there, Mr. Reese was not on scene. I talked to the victim. The victim explained that she was being harassed via phone by her ex-boyfriend. She stated they had been going back and forth for a few days. And this particular day, he stated that he was coming over. Once he arrived on scene, his parents actually tried to meet him there. Once they got there, on the Ring camera, at one point, you could see the dad trying to calm him down as he was knocking on the victim's door. And then at that point, the victim stated she was inside the house. She could see him on Ring camera walking towards the car. He then proceeds to press open her gas tank and slap the door off onto the floor. And him and his parents left soon after.
You said he slapped the gas tank
The
lid
door.
cover? Oh, the door.
Yes, the cover onto the floor.
What kind of car was it?
It was a Hyundai. I believe it was a 2000. I'm sorry, I have it here. It was a 2013 Hyundai Santa Fe, white in color.
And who determined the value that the damage to the gas tank covered door would cost?
The victim.
And that's all I have.
Ma'am, I'm sorry.
I have no further questions.
Mr. Lane?
Good morning, officer.
Good morning.
You said it was the gas tank cover door that was damaged?
That was broken off. Yes, sir.
So it was
When I got
completely,
there, it was on the ground. Yes, it was on the ground.
okay, did you take pictures?
I did not take a picture of the door on the ground.
Was there anything else broken?
No,
Okay. So the actual gas cap that you screw into the top of where you put the gas in the car, that was okay?
yes, that was still placed.
Okay. And you said you reviewed some video footage from the door cam?
Yes, so I asked her if I saw the ring camera. I asked her if she had video footage of him actually damaging the door. She said that because he was so far away, it did not show him damaging the door. It did show him at his property right when she called police around the time, maybe a 5-minute increment.
Did it
Him and
show
his
her?
father.
Oh, I'm sorry. Did this video footage show her waving a gun at my client and his parents?
No, the video footage that I revealed, it only showed the suspect and his father.
Did you interview my client?
I did not.
Okay. Did you
He was
interview
not on scene.
Did you interview my client's parents, either the mother or father?
No, the mother was on the phone with the victim once I arrived. They were actually discussing the pay or how much it would take to to fix the vehicle.
And how did they arrive at the dollar value?
The victim, that's the amount that she gave me.
Do we know where she got that number from? I'm seeing $250 in your report.
Yeah, she was doing research on her phone. I didn't ask her exactly what shop or where she would buy the materials from.
But the video footage didn't show the actual gas tank cover being broken off the car, correct?
No, that was away from the door.
Okay. I have no further questions, Your Honor.
Okay, Ms. Jefferson, do you have any follow-up?
No, Your Honor, the state rests.
Okay, may Officer Farley be excused from this case? I know she has another case, but may she be excused from this case?
From this case, yes, Your Honor, the state would submit.
Okay, Mr. Lane?
The defense would submit, Your Honor.
Okay, I'm gonna find that there's sufficient evidence to bind this over to state court. Now, Mr. Lane, I think that's it from your pre-prepared cases. Is that correct?
Actually, Your Honor, I just had one left. Well, actually, you know what? I'm mistaken on that because Ms. Lindsay Smith was one that was out the bond. So,
okay.
Yes.
Okay. So hold tight, Mr. Lane. I'm going to switch over to Mr. Little, and we can deal with Mr. Greer. And then I see a couple other officers that I'm going to try to get out of here. Looks like Officer Allen, Officer Wynn, and Officer T-Mont, and Officer Lamb, and Officer Kilgore.
Your Honor, I think I also have Officer Farley for Willie Williams.
Okay, so we'll do Mr. Greer, and then we'll let me see with Willie Williams.
And Judge, Mr. Williams was one I was needing to meet with.
Okay. Okay. All right. And Officer Lane, I believe. See Jason.
Your Honor, this is Jill.
I'm sorry.
I'm sorry, Your Honor. Willie Williams, he has court in Judge Haywood courtroom this morning also.
What? Oh, so is he?
He in Judge Haywood courtroom right now.
Okay.
But we'll check and see if he finished. If he finished, then we'll bring him back over here.
Okay. All right. So let's deal with Mr. Greer and Officer Farley.
Greer.
Yeah, just remind him that sentence is yours.
We have Officer Wynn. That's one of your cases, Mr. Little, with the 2022 W808116 with the sexual battery. But Ms. Jefferson, I don't see Officer Little, or I'm sorry, Officer Tate. And if I call that calendar and Officer Tate is not here to present evidence on those two cases, they will be dismissed.
I understand, Your Honor. If I could just check with the investigator in the office about the whereabouts of the officer.
Yes, ma'am. That's fine. And like I said, I don't try to hide the ball. Because when we're done with the cases where we got the officers here, that's when I'm going to allow everybody to speak to their clients, you speak to Ms. Pass, and then we'll convene back together. But I don't want to have these officers who've logged on to just be sitting here. And for their the clients of the lawyers to be sitting there waiting on stuff. So if we can try to move it, we're going to try to move it.
Yes, sir.
Mr. Grayer, sir, this is your preliminary hearing. I need to caution you, as I caution everyone, that anything you may say here is not privileged or private. So please don't say anything without at least speaking to your lawyer about whether it's a wise idea to speak about anything. But don't say anything that you wouldn't want the whole world to hear. Do you understand that, sir? We gotta unmute Mr. Gray. Grayer, I'm sorry. At the jail, can we unmute Mr. Grayer? Okay, Mr. Grayer, did you hear what I just said?
Yes, sir. I heard you, sir.
And you understand that?
Yes, Your Honor.
Okay, thank you, sir. For the record, this State of Georgia versus Leroy Grayer. Mr. Grayer is charged in warrant number 2022 WA08168 with committing the offense of criminal trespass. Mr. Grayer is here represented by Mr. Little. The state is being represented by Ms. Jefferson. Ms. Jefferson, would you swear in your witness and begin your examination?
Officer Farley, can we swear you in again? Raise your right hand. Do you swear or affirm the testimony that you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
And if you could state your name and again where you are employed.
Officer Farley, employed with Clayton County Police Department.
And were you so employed on the 15th of May, 2022?
Yes, ma'am.
And on that day, did you respond to 1219 Gardenwood Drive in Atlanta in reference to a domestic dispute?
Yes, ma'am, I did.
And was that location in Clayton County?
Yes, ma'am, it was.
And then can you tell us the basis for the issuance of the charge of criminal trespass, damage to property against Leroy Grayer?
Yes, ma'am. When I arrived on scene, I spoke with the victim. The victim stated that she was afraid of her son because he had just kicked her door in. She stated that morning he had been following her around and telling her what to do and what she could not do. She stated to get away from him, she went into the room and closed her bedroom door while she called police. At that time, he proceeded to kick the door in.
Officer, was Mr. Grayer living in that residence?
Yes, he was.
Your Honor, at this time, the state will dismiss this warrant.
Okay.
No objection, Your Honor.
Well, that was an easy one. Mr. Grayer, these charges are being dismissed against you. The state may or may not choose to bring these charges back up at a later date. They have 2 years from the date of the incident to do so. Once the paperwork is received at the jail, this will be processed. And if you don't have any other charges that are holding you, you will be released. Officer Farley, is that,
Yes, sir.
is that your last case?
I have a Williams case as well.
Williams.
That was the one where the Mr. Williams is in the courtroom, I think.
Yeah.
Yes, Your Honor.
Officer Farley, you can just basically, I would say stay in communication with the solicitor's office, because I don't know what's going to happen with Mr. Williams, with the Williams case yet. If can't get Williams in, it may be something that gets continued. But I just don't want you just wasting your time. But please stay in close contact with the solicitor's office. So if that's the case that we're going to have to bring up, they can reach you and you can come back. Okay.
Okay. Thank you.
Judge, Your Honor, we have Williams is on his way. He have not seen Judge Haywood, but they sending him over.
Okay. Do you have an ETA on that?
Less than a half a second. He's coming through the doors now.
Okay. Well, let's try to get Mr. Williams done so Officer Farley can go about her day.
And Judge, on Mr. Williams, that was one I was needing to meet with him as well.
Okay. So Officer Farley, it's probably going to take a while to get to the point where Mr. Lane is able to speak to his client. So Ms. Jefferson, I'm gonna place it in your hands as to, how you want to keep in contact with your officers. And if you feel, whatever you feel is necessary, is fine with me.
Let me just ask Officer Farley. Officer Farley, are you on duty right now? And what is your, do you have to, what is your shift today?
Yes, so I am currently on duty from 6 a.m. to 2 p.m.
And you'll be, can you stay on the Zoom link?
Yes, ma'am, I can.
Okay, or we can figure out how to log you back on in a little bit. Either way, we can be in touch with you to have you come back.
Okay, we could do that. We could be in touch.
That will probably work best for the state, is if we can just log her back on, perhaps at 11 a.m.
Yes, ma'am.
And that's fine. And just, Ms. Jefferson and Officer Farley, having this conversation, I'm not gonna, hold anybody's feet to the fire. You've been here, and Mr. Lane does have the need to speak to his client. So I'm trying to accommodate everybody as best as possible. So just stay in just stay in contact with the solicitor's office. And Ms. Jefferson, when we get to that point where the case is being called, I'll give you the time you need to bring Officer Farley back online. Okay.
Thank you, Your Honor.
All right. So I see in Officer Ford you're gonna be in that same boat. Because I believe your last case, Mr. Lane needs to speak to the client. So Officer Ford, with the same discussion we just had with Officer Farley, if you are willing to make sure you stay in range where the solicitor's office can reach you when your testimony is needed, I'm perfectly fine with you logging off and logging back on. Okay, I see we have an Officer Tucker and Officer Owens. Officer
Tucker is here on the case that we need to discuss with Ms. Pass.
Okay. Okay, thank you, Ms. Bilheimer. Ms. Bilheimer.
Yes, sir.
Is it possible for me to place you in a breakout room with Ms. Pass?
Yes, actually you can. That would probably be better since I'm a little familiar with the case. So then I can let Ms. Jefferson know what direction it's going to go in. So yes, Ms. Pass and I can definitely speak.
Thank you. Thank you for bringing that to my attention. Okay. Ms. Pass, I'm going to place you in breakout room 1 with Ms. Bilheimer so that the two of you can have that discussion. And thank you for bringing that to my attention. And I'm trying to move this stuff along as quickly and efficiently as I can. So Ms. Bilheimer, Ms. Pass, the two of you should be able to go into the breakout room and have whatever discussion you need to have about her case. All right, we have Officer Tucker. Do we know which case, Officer Tucker? Officer Tucker, are you still there?
Yes, Your Honor, I'm here.
What case are you here on?
Last name Sanders, Jadarius Sanders.
Judge, that's the case, I believe, with Ms. Pass.
Yes, I'm sorry. And I was just told that. And I'm sorry, Officer Tucker. So you need to stand by.
Yes, sir.
Until we figure out what we're going to do with that.
Okay.
Officer Owens. What case is Officer Owens here on?
I'm here for Officer Timmett's case, sir. For Dwayne Keith.
Dwayne Keith.
Dwayne Keith. All right, let me see. What do my notes say? The officer is Kale. But again, Mr. Little, I listed, did not list the name. Is that your case?
It is, Your Honor, and we are ready.
Okay. Can we bring up Dwayne Keith? Mr. Little, once we get to the end and we have the conversation about criminal trespass, it's going to be a barn burner. Ms. Jefferson, I think you're going to be happy to hear it also. Mr. Keith. For the record, this is position 15, State of Georgia versus Dwayne Keith. Mr. Keith is charged in warrant number 2022 WA 08225 with committing the offense of obstructing an officer. He's also charged in warrant number 2022 WA 08226 with committing the offense of giving a false name, address, or date of birth. Mr. Keith is here represented by Mr. Little. The state is being represented by Ms. Jefferson. Mr. Keith, I need to caution you that anything you say here is not privileged or private. So please don't say anything you wouldn't want the whole world to know, and don't say anything, especially without speaking to your lawyer first. Do you understand that, sir? Okay. Ms. Jefferson, you may swear in your witness and begin your presentation.
Officer Owens, if you could unmute and make yourself visible. Thank you. If you could raise your right hand. Do you swear or affirm the testimony that you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. And if you could state your name and where you are employed.
My name is Officer Jalen Owens. I'm currently employed with the Clayton County Police Department.
And were you still employed on the 17th of May, 2022?
Yes, ma'am.
And on that day incident, on Riverdale, Norman Drive and Riverdale Road.
Yes, ma'am.
And that location is in what city?
It is in Atlanta, Georgia, but it's still in Clayton County jurisdiction.
Clayton County, Georgia. Okay. And can you tell us what was the basis for issuing these charges or taking these charges of obstruction and giving false name against Mr. Dwayne Keith?
Yes, ma'am. So the charges came about after taking in the totality of everything. I came to assist in a traffic stop where contraband was found, such as methamphetamine and meth pipes with residue in it. He was one of the passengers in the U-Haul van. We made contact with him after the other three were arrested, and he was trying to take possession or ownership of a gun that our original offender claimed that he was transporting for another friend. So I conducted a further investigation where Mr. Keith, he was claiming that he knew the law and he didn't need proof of ownership to claim the gun or whatever. Throughout his belongings, I found a scale with residue on it. I didn't find anything to go with it, so I didn't charge him with that. He had a backpack with a PlayStation and mail from my address with 3 other people's names on it. So I was asking him, where did he stay? Everything like that, because we have to do a report regardless, and we need this information. He didn't want to advise where he stayed. He kept repeating 127 Stockbridge, Georgia, which is not a valid address. He claimed he didn't want to talk to me because I was getting too personal. So I said, fine. So I asked his friends who were in custody, I asked him, where did he stay or where did they pick him up from? They told me he stayed down the street at Flash Hills Road. Then during that time, one of his other friends also advised that that's where he just got picked up and he didn't help anybody move. He was just there as an advocate to say they were moving. So that's why I went back over there to conduct a further investigation. During that time, Mr. Keith still refused to give me the valid address. So when I went to place him in custody, that's when he tried to pull away from me and start tensing up his muscles and everything. I just held him in the hold and advised him that all he needed to do is give me a correct address. So he continued to say 127 Stockbridge, Georgia. I said, that's not a valid address. And then that's when he said, oh, you talking about flash shows? I said, correct. What is the address there? He still refused to give it to me. And so that's why he was arrested. He didn't want to give me an address for our incident. We conducted a further investigation. We couldn't even do a complete investigation.
And officer, just so that I have clarification, You responded to an incident involving a number of other individuals. Were
Yes,
those
ma'am.
other
So,
individuals arrested?
yes, ma'am. Officer Rudy conducted a traffic stop on a U-Haul. It was Mr. Dwayne Keith in the front passenger seat, the driver who was driving on a suspended license, if I'm not mistaken, and 2 passengers that was in the back of the U-Haul van sitting in folded steel chairs with a dog.
And one of the individuals in the back of the U-Haul, that individual, that was one of the individuals, was Dwayne Keith. Is that accurate?
Dwayne Keith was the front passenger, correct?
Oh, I'm sorry. He was the front passenger. And during that traffic stop, did I hear you say that there were suspected narcotics or weapons identified?
Correct, ma'am. When I arrived, that's Officer Rudy or Officer Timmett informed me that there was a firearm in the vehicle, and other officers were watching the individuals in the vehicle. So the driver who was driving on suspended license, when he was arrested, that's when he told Officer Timmett that he was transporting a firearm for a friend. He didn't say specifically which friend, nor that the friend was in the vehicle. He just said he was transporting it for a friend after he said no to initially having a firearm.
Okay, did anyone do any additional, I guess, identification regarding, no, let me strike that. I'm gonna ask a different question. Were there any drugs that were in plain view inside the vehicle?
When I approached, no, ma'am. As I was approaching the vehicle, the rear passengers were actually exiting out the back of the van. And I saw that they had fanny packs and everything on. So that's when I asked them, do they mind if I check to make sure they didn't have any weapons on them, anything like that. The first passenger that exited the vehicle, he provided me with the male fanny pack or whatever. And as soon as I opened it, that's when I felt I saw the meth pipe. In that bag, he also had the little tubeware container, which contained a single methamphetamine crystal, which also tested positive.
I have nothing further.
Mr. Little?
Thank you, Your Honor. Morning, Officer Owen.
Good morning.
So my client, Mr. Keith, wasn't charged with any drugs or contraband, correct?
No, sir, because he wasn't in physical arms reach or possession of anything.
The alleged drugs that were found in the back, like storage compartment of the U-Haul?
Yes, sir.
And they were in the physical possession of the suspects that were in the back of the U-Haul?
Correct.
Okay. When you made contact with Mr. Keith, did you ask him for a name and date of birth?
Yes, sir.
Did you run that information through GCIC?
The assistant officer did. When I initially asked him, I think he responded that y'all already got that. And so I asked him again, and then he eventually gave it to me.
So were you able to run that information through GCIC?
Correct.
And did that return with a valid driver's license?
It did, which was later confirmed. It confirmed that it returned to an address in Stockbridge. Correct.
That address being 127 Bel Air Trail, Stockbridge?
That is correct.
Okay. Did that identification come with a picture, like a driver's license picture?
Our assistant didn't have a picture. To my memory, it didn't, and nor did he have his license on his person.
Okay. But the name and date of birth he gave you did come back as a valid person.
Correct.
Okay. And that person had an address of 127 Bel Air Trail in Stockbridge.
Correct.
Okay. And is that how you were able to identify Mr. Keith?
That is how I identify him, through his name and date of birth, correct?
Okay. Now, was that identification done before you attempted to place Mr. Keith under arrest?
That is correct.
Okay. So the basis of the giving false info charge that you requested the warrant for is based on the idea that he didn't give you a valid address.
It's based on the idea that he didn't give me a valid address multiple times after I asked, nor that his friends that he was with, or people that he claimed to be his friends, they said that he didn't live there and he lived at an address which was down the street from the incident location.
So you charged Mr. Keith with giving false info based on the statements made by people that were not Mr. Keith.
Correct.
Okay. What was the basis for your obstruction charge?
For the basis for the obstruction was that he attempted to pull away multiple times and use strength to snatch away from me or pull me with him into a direction.
And that was when you were attempting to arrest him?
Correct.
For the giving false info?
Correct.
Okay. Those are the questions I have this time.
Ms. Jefferson, do you have a motion?
Your Honor, at this time, the state would be seeking to dismiss these warrants.
Thank you. And this case, I think I was doing first appearance when this case came across, and there were, I think it was 4 individuals. And Mr. Keith, these charges are going to be dismissed. I do not blame Officer Owens, because it smells wrong, but everybody other than the driver of that U-Haul, I think I remember that case because I have concerns about the reason that they were arrested. I think the driver, there was clear evidence to arrest the driver, but the other people, I do remember that one. So thank you, Ms. Jefferson. Mr. Keith, these charges are going to be dismissed against you. When the jail receives the paperwork, they will release you. And that's going to take a few hours to have that stuff done. Do you have any questions about this process, sir? Okay.
Thank you.
So you get the chance, you need to thank both Ms. Jefferson and Mr. Little. All right, let's see. Who do we have?
Judge, can Officer Timmett and Officer Owens, they can be excused. I believe those are the only cases that they are here on, unless I'm mistaken. Officer Timmett, that was the only case, correct?
That is correct.
Okay.
So yes, Officer Timmett can be excused. Officer Owens can be excused. We're still holding on Officer Tucker and Officer Ford. Officer Kilgore. What case is Officer Kilgore here on?
I believe that was Jackie Fleming.
Fleming.
Yeah, that's correct, Your Honor.
Okay. And that's going to be Mr. Little.
That is, Your Honor. That was a case that I actually requested a conference on.
Oh, okay.
Had a chance to meet with Ms. Fleming.
Okay, so we're gonna have to hold for you, Officer Fleming. Let's see. We have Officer Lamb and Officer Wynn. I think those are cases that are ready to go. Officer Wynn.
Your Honor, this is
Nope. Yes, ma'am.
I think her name is Dominique Alexander.
Mm-hmm.
She is a female and she is very aggressive and she is down in her cell and they cannot bring her up. And I heard that she was supposed to be doing a hearing.
Is it? I don't have an Alexander.
That's position 40, Your Honor.
Position 40.
And Mr. Litter, that's what I want to let you know, that she is being very aggressive down there and they can't get her to come up.
Okay. And it appears it says the officer is Alan Dorian Lamont. And I don't see a Lamont here.
Oh, I'm here, sir.
Oh, thank you, sir. Okay, so it's Dorian Allen.
Yes, sir.
Okay. And is that your case, Mr. Little?
That'd be mine, Your Honor. David Suh.
Mr. Suh, if we get Miss Alexander squared away, would you be ready to move forward on that, Mr. Suh?
Yes, this case was actually reset from the last preliminary hearing calendar, so we've been waiting.
Okay. Miss Pass and Miss Bellow, if you don't have an announcement, that's fine, but. Okay.
It's gonna be a report, a consent and a waiver.
Uh-oh. I'm gonna ask Miss Bellow to speak first and then you speak second, Miss Pass. Miss Bellow.
Sorry, Judge, mine was cutting up, but we do have a consent bond and a waiver of the prelim. And Officer Tucker was on here for this particular hearing. So if she doesn't have anything else, then she would be free to go. And we're preparing the information to prepare the order for the court as we speak to mail to send to the court.
Okay, and is that your understanding, Miss Pass?
Yes, Your Honor, it is.
Okay, so with that announcement, Miss Pass, you can be excused. Miss Bellow, I don't know if you're here for other matters, but if you don't need to stay on, you can be excused also.
I'm just in the background, Judge, just to make sure everything goes smooth with Ms. Jefferson.
Okay.
Thank you, Judge.
You're welcome. So I'll just wait until I receive the paperwork and just make sure it gets sent to myself and Miss Mary, and I'll sign off on it today.
Okay, sure will. Thank you, Judge.
Thank you. So at the jail with Miss Alexander, is that something that we can do? And
I'll try calling down. I'll try calling down to the jail and down to the housing unit to find out whether or not she would be able to come up. But that was the news that I got when I called down there for her earlier. So I'm gonna try again. I'm calling right now, Your Honor.
Okay, and Mr. Call, K-A-H-L, I just saw you log in. Are you here on a case?
That's a firm. It's going to be the Jones case number 6916.
Your Honor, I think that was Delmonte Jones. Is that correct, officer?
Yes, that's correct.
And I have on my calendar that Mr. Jones posted bond.
I have that also. So Officer Call, thank you for logging in. You can be excused, sir.
Thank you. Y'all have a good day.
You too. So let me see. Mr. Jason Lane. Are you with the solicitor's office?
City of Jonesboro Police Department.
City of Jonesboro. You have a very intense stare, sir. I've noticed your intense stare. What case are you here on?
Reginald Corvin Oliver.
Oliver.
That's position 25, 26, 78.
Okay. Miss Jefferson, you're starting to lag a little bit. I hope we're not burning through your minutes.
Yeah, I just got a little notification. My internet is a little wobbly.
Yeah. I have Mr. Oliver as being out the bond. Or though they said that he's there, but he was listed as being out to bond. So let's at the jail. Do you have Mr. Oliver? That's Mr. Sudd's case.
It's actually mine, Your Honor.
Oh. Okay. If you have Mr. Reginald Oliver, would you please bring him over? And we can deal with that case with Officer Lane.
Yes, I have him.
And Mr. Little, while I'm looking at my calendar, the Chumudgeon Perkins, I don't have an announcement written down in my notes. Mr. Perkins?
For Perkins, I was requesting a conference, Your Honor.
Okay. All right. Mr. Oliver, sir, can you hear me?
Yes, sir.
There's been some confusion this morning as to whether you were released on bond or not. Our records are showing that you are what we call out on bond or OTB, out to bond, but you're still here. Are there any other charges? And you don't need to tell me what they are, but did you make bond on these charges and then you're being held on something else?
No, sir. I don't have any other charges in.
Okay. Well,
when I go to look him up at the jail inmate search, Your Honor, he doesn't appear on there at all. So it's not like he's booked in on anything, but clearly he's there. Do you know if anybody paid your bond, Mr. Perkins?
No, this is Mr. Oliver.
No. Oh, Mr. Oliver. That's right. Sorry. Mr. Oliver, did anybody come to the jail and pay your bond?
Not that I'm aware of.
Let's do the hearing then, Your Honor. We're here.
I got CP made up. If you guys want to give me 5 minutes, I can look.
That would be great.
Okay. And I don't have the name of the charge for warrant number 2022 CW 52130. I have speeding, fleeing from an officer, improper lane change, and it's a $1,500 bond. So it must be like
driving.
Judge, I have that as reckless driving.
Okay.
And the other charge was failure to maintain lane. It wasn't
improper lane change. Yeah, it's essentially the same thing. It gets the interpretation from going from the officer's pen to what the jail may write it in. So an improper or failure to maintain lane will get written in as a improper lane change.
Judge, I'm going to have to call the jail. Can you ask Mr. Oliver, is he junior or senior?
Are you junior or senior, Mr. Oliver?
Neither.
You're neither.
He's neither.
You said neither.
Okay. Might want to go to somebody else for a second.
Okay, so we're gonna start this hearing, Mr. Oliver, because we got the officer here, and you know we'll figure it out. For for these charges, they're basically citation worthy charges. So the fact that you've been in jail for a couple weeks on these charges is not lost upon me. So for the record, I'm going to call position 25, State of Georgia versus Reginald Oliver. Mr. Oliver is charged in warrant number 2022 CW 52127 with committing the offense of speeding. He's charged with warrant number 2022 CW 52128 with committing the offense of fleeing from an officer. He's charged with warrant number 2022 CW 52129 with committing the offense of improper lane change or failure to maintain lane. And he's charged in warrant number 2022 CW 52130 with committing the offense of reckless conduct. Mr. Oliver is here. He's represented by Mr. Little. The state is represented by Ms. Ferguson. Ms. Ferguson, you can swear in your witness and begin your examination.
Sorry, Judge, it's still Jefferson. It's okay.
Oh, what did I call you?
Ferguson.
Ferguson. Oh my goodness. Okay. I'm sorry, Miss Jefferson. I truly apologize.
That's okay. That's fine. Let's see, Officer Lane, would you raise your right hand, sir? Okay. I assume you're on a phone because it's a little shaky.
Yes,
do you swear
Okay.
or affirm that the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. You can lower your hand.
Okay.
The other one.
That better?
Okay.
Is that better?
And if you could state your name and where you are employed, sir.
Jason Lane. I'm currently employed with the City of Jonesboro Police Department.
And were you so employed on April 28th, 2022?
Yes, ma'am, I was.
And on that day, did you respond or conduct a traffic enforcement issue within the city limits of Jonesboro and Clayton County?
Yes, ma'am.
And can you tell us exactly where? Was this on a highway, a road? Can you tell us the location?
It was on the city street, Turner Road near Elaine Terrace street that leads to Lake Jodico Road if you're going back eastbound.
Okay. And while you were there in that location, what was the basis for the citations and charges that you took out? Speeding, fleeing, reckless driving, failure to maintain, or improper lane change against Mr. Oliver?
I was stationary.
Oh,
near
wait a
Terra-
minute. Hold on. We don't have a judge.
Oh, okay.
I'm still here.
Okay.
I'm listening, but I got something else going in the background.
Okay.
With court business, so I am listening.
Thank you. Sorry. Sorry, sir. Mr. Officer Lane, if you could continue.
Yes,
Your
ma'am.
Honor,
I was stationary next to Tower Record that's located on Turner Road near Elaine Terrace in this parking
Your
lot.
Honor,
I'm sorry. I'm sorry, Mr. Lane. I'm gonna stop you. I hear somebody asking for my attention. It's
Jefferson, he's not Reginald Oliver.
He's not?
No, sir. I get the
Okay.
Oh, wait. Can I have an explanation? Can I have an explanation for that?
That's where I was
Your
trying to
Honor.
get you to read the note.
Okay.
He said his name is Nogira Oliver. I don't know if he had the same person. I don't have a middle name for this one. He just said Oliver Reginald.
What's his date of birth, Deputy?
February 17th, 94.
That's
February
not him.
17, 1994.
That's not him.
February 17, 1994? All right, hold on, guys.
Okay. Okay. Then this is a new one. This is a new one on me. So
I think he did make bond.
it appears that he did. Mr. Oliver.
Yes, sir.
Have you heard us referring to you as Reginald Oliver?
No, sir. Just Mr. Oliver.
Okay. Just for the record, sir, can you tell me your full name and the year of your birth? I don't want you to put your full birthday out, but tell me your full name.
Jeremiah Caron Christopher Oliver.
So you're not the person. You're not the person that we should be dealing with.
No, sir.
What do you know your charges, Mr. Oliver?
Yes, sir.
Did you hear me not say charge with speeding, fleeing from an officer, improper lane change, and reckless conduct? Are any of those charges that you've been charged with?
I did. I just didn't want to interrupt you, sir.
Okay.
It wasn't the right time to tell you.
Your Honor, I can tell you, I met with the person I think is my client, Reginald Oliver, and on Friday, and that is not the man I met with, Your Honor.
Okay. Okay. So, Mr. Oliver, are you charged with felony or misdemeanor offenses?
Felony offenses, sir.
Okay. So you're not supposed to be here.
No, sir.
So thank you, Miss Mary, and thank you at the jail for interceding. The thing you have to understand, Mr. Oliver, is I've never met you a day in my life. So you're a name and a file. And we say that stuff so that if there is a problem, you can step up and say, hey, that's not me. Officer Lane, it appears that the real Mr. Oliver has in fact made bond. I apologize for your having to be on here for 2 hours, but sir, you are excused. Miss Jefferson and not Miss Ferguson. I'm going to stop this proceeding because it appears as though we're dealing with the wrong person.
Yes, sir.
Mr. Oliver.
Yes, sir.
Again, sir, do you know when your preliminary hearing is scheduled?
I've been incarcerated for 31 months, sir.
31 months. Okay.
Your Honor, this is Deputy Jackson over here at the jail. When we called for Mr. Oliver down at the housing unit, they sent us the wrong Mr. Oliver. They're actually sending us the correct one now. We just called down there and they said he's on his way.
And he's still in jail?
I thought he was out of jail.
Mr. Little, do you have the LE number for your client handy?
I might have it. Usually I get the LE number by looking him up in the jail, and since I can't find him in the jail, I don't.
So Mr. Little, what is your client's full name?
It is Reginald Corvin Oliver Jr.
Okay, so I have the LE number of 197-6448. I show that he's out to bond. Judge, take us off YouTube.
Okay.